Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends, and happy Wednesday. It is Hump Day, October 8th, 2025, and we're going back to Dedham today. This is confusing because it is a hearing that is docketed under Aidan Carney's case, Commonwealth v. Aidan Carney, but this is regarding the motion that we went over that Cosgrove filed to search the cell phone of Karen Reed that they've had in their possession since January of 2024. We were a little bit confused about how Cosgrove had standing to do that. And we were confused because he filed it under a search warrant number instead of an actual docket number. But it seems to have been docketed under Aidan Carney's case number, but it is regarding Karen Reed's phones. So yesterday we went over the opposition to that motion by Cosgrove to appoint the taint team to reduce the, I'm sorry, what? My bit rate is a bit down today. I don't even know. Uncivil, I don't even know what that means. What does that even mean? Does it mean I'm glitching? I don't know what that means. Am I glitchy? Yesterday, and it's in below for you in the show notes. If you missed it yesterday, we went over the opposition, and Steve Buzang is the attorney for this because Steve Buzang is the attorney that Karen hired to do the release of her property. Remember, he made the motion to get her SUV back, and she made a motion to, he made a motion to get her phones back. And so instead of giving her phones back, Cosgrove made this motion for the special taint team to search Karen's phones, even though they've had them since, even though they've had that since 2024. Oh, hold on a second. Who the fuck? I'm sorry. Oh, Jimbo Clip. What a disgusting pig you are. You know what's really nice this time of year? Block Island. I'm surprised nobody found that. Found you before that. Hold on. Done. I'm gonna reset the ability to chat. Hold on. Oh, please. Bye-bye. They're calling it an absurd fishing expedition. Let's take a look. Ted Daniel did a story on this yesterday. I don't know if anybody is, I don't know if there's going to be a camera in the courtroom, so I got the Zoom feed up, but let's take a look at Ted Daniel's story from yesterday because he was on top of it. I don't even know if Karen Reed is going to be there. Do I have any boots on? Are there any boots on the ground today in Norfolk County? Yeah, some people still have not recovered from the Bradle attack yesterday by that Judge Drexler. Dreckler. Somebody corrected me, said it was German, so I think it's Dreckler, that it's not Dreschler. Thank you. Hi, Nick Rocco. Nick Rocco is here, says she's not going to be there. Okay, so Buzang is appearing for her. I don't know if there's a camera in the courtroom, but let's listen to catch you up anyway, Ted Daniels' story from yesterday on Boston 25.
Karen Reed's fight to get her phones back is heating up. I'm 25 investigator Ted Daniel. As we first reported last month, a special prosecutor is holding on to the phones as part of an ongoing witness intimidation probe. Reed's lawyers are challenging that, and they're firing back in new court documents. Reed's attorney, Steve Buzang, calls the request to search the phones absurd and a fishing expedition intended to punish and harass Miss Reed. State police took the phones in January of 2024 during a failed attempt to indict Reed and Aiden Carney, a.k.a. Turtle Boy, together on charges related to witness intimidation. It appears Special Prosecutor Robert Cosgrove wants to try again, months after Reed was acquitted of John O'Keefe's murder. There will be a hearing on this matter, and ultimately a judge is going to have to decide what happens to the phones. Attorney Buzang declined to comment on his new filing. The Norfolk DA's office has previously told me they can't speak for Cosgrove because they say he works independently.
Oh.
I'm Ted Daniel for your local station, Boston 25 News.
Well, not for long, because Aiden's attorneys have made a motion to, well, that was really weird because the volume just jumped as soon as it turned to a different segment, and now it blew out my ears. Cosgrove should be recused from this because Lindsay Gattani is a potential witness in all of these cases, and she, in fact, is the reason they probably seized Karen Reed's phone because of her interview with Tully, wherein she said that Aiden was communicating with Karen and that they used Signal and all these other kind of things. So because Cosgrove is a witness in that case, because Lindsay has sued him personally and has also filed a notice of claim or a demand notice on Michael Morrissey's office, the argument is, and I agree with it, that the entire Norfolk County DA's office should be recused from prosecuting anything regarding Aiden Carney, as should Cosgrove. So it is stateless right now. And yet, here we are. I'm going to get into the Zoom room right now. And Life on Makeup says that I've been such a positive influence on her friend Jason's life, and he's 45 today. So happy birthday, Jason. Happy birthday, Jason. I hope you have the most amazing day. Thank you, Life on Makeup, for always being here and being such a great contributor to the channel and the community. The community. All right, so I'm waiting in courtroom 1. If anybody finds out that it's in a different courtroom, when I called the court this morning, this is the one that they gave me. And then yesterday they said another weird thing too, because I have like the Zoom information for each courtroom. I have courtroom 25, I have the main room. And so they tell me now that the Zoom follows the clerk and not the courtroom. I don't know what the hell that means. Oh, Tom Gully's asking in a roundabout way how Yes was last night. Well, I'll tell you something, ladies. If you're in your 50s and you ever want to feel really, really, really young, just go to a Yes concert. I want to tell you that the average patron at this show was probably 75 years old. I mean, I guess that tracks too, because their first album was released in 1971. And it was at a very small venue, and it was kind of like a Yes cover band with Steve Howe. So it was good, but it was fully seated, and I like to stand during concerts. I'm a mover. I don't like to be confined to a seat. And so luckily it's in a place kind of like the Wilbur, I would say, but maybe a little bit smaller. There's bars on each side, so you could kind of like stand. I'm not a sitter. And the way they had these folding chairs jammed in on the floor that is usually just standing is like, it was weird and it wasn't for me. So I prefer to stand. So that's what we did most of the time. It was fun, but it's like, yeah, I love that 70-year-olds are out there enjoying life. Yeah, it was crazy. It was crazy. And it was like 90% men, but it's fun. Thank you, Dee, for becoming a member, and Roy Barefoot for becoming a member. And Casey Paralegal loves the cupcakes, just loves the, oh my gosh, Clamasu sent me this amazing thing yesterday. Somebody posted on Twitter, they started a hashtag Melanie on SVU. And they said, we love Melanie Little. She's a law tuber, and she's also an actress, and it's her dream to be on SVU. And so and she tagged everyone. Hold on, I got to give her credit. She tagged Ice-T, and she tagged Dick Wolf, And Ice-T liked the post. This is so funny. And then I guess she asked Suzanne to send it to me. And it was so crazy and awesome. So let's shout out. Let me put this in a. Let's shout out the original person who tweeted this into the ether, into the universe. And her name is Lilou, Lilou. Hold on. And it's crazy. Wouldn't that be crazy if the cupcakes got me on SVU? I would love that so much. Thank you, Jenny T, for being here for a year. Happy anniversary to us. So here it is. Thanks, Glamasus, for sending this to me. And it says, Ice-T liked the hashtag Melanie on SVU hashtag. And Lilou, Lilou, is the one who posted it. Says, let's get it out there, cupcakes, hashtag Melanie on SVU, hashtag Melanie on SVU. And then she said here, hello, hashtag Melanie Little. Because I'm a huge believer in the squeaky wheel gets the oil, I put in a good word for you and forwarded your IMDb to Ice-T. That's Ice-T's, I guess, Twitter. And Wolf Entertainment, I know your dream is to be on SVU. Oops. I'm praying you get a call back. And then Ice-T liked it. Look, he liked it. There it is on the bottom. It's him liking it. I mean, how awesome is that? All right, Ice-T, I see you. I see you. There it is. So how crazy is that? I don't know what you're talking about. Oh, that wasn't directed to me. Okay, so that was funny and fun, and I'll allow it. I'll allow it. Yes, that's what it's kind of like. A lot of walkers and a lot of mobility issues in the crowd, which is not a thing, but it's just I'm used to going, I guess, to concerts with like a younger crowd. Rockers on walkers concerts bring out vintage. I know, and I got to say, look. Smarter Harry. I am a huge Genesis fan, huge. And I saw Genesis, I can't remember when it was, within the past couple of years. And Phil Collins is not in good shape. And it was just, I don't know, it just made me sad. SVU is a Law and Order Special Victims Unit. Thank you, Karen. Starring Mariska Hargitay. And I've auditioned for it several times. I've just never booked it. And I've also auditioned several times for Organized Crime. Because, I love Christopher Maloney. And, you can put that on the universe, too, if you want. I mean, I'll allow it. Amy became a member. Welcome, Amy. And Amy, thank you for your 20, says, hello, I bought 2 lip stains yesterday. Coming up on 55 in December. Us older Gen Xers need different products. Thanks for the recommendation. Love your channel and the others in the Justice League. Thank you. Thank you. Yeah, it's Wonder Skin. I think I can tag products now in my videos, and I think I tagged it yesterday, but there's also an Amazon shopping list in the show notes below. And because people always ask me about makeup and the equipment that I use to stream and the camera and the ring light, it's all in there. It's all in there, including a bunch of fun products for your home that you might not even know you need unless your kids eat a lot of ramen. And then you know that you need this over-the-counter strainer so they can dump their ramen bowls in there instead of dumping them in the sink. Thank you for your 20. My alternate reality is here and give to 5 memberships. Thank you so very much. I appreciate you. To the 5 randomly gifted members. Welcome. Fitness on Call became a member. Welcome. And going off the rails, Jen went to 3 Dog Night a few weeks ago. At 53, we were the youngest there. I know, it's funny, right? Thank you. Thanks for your 5. And D says, Melanie, I subscribed but can't chat. What happened? I don't know. It is set. You have to be subscribed for 2 hours because of the troll factor. So if you have not been subscribed for 2 hours, then you can wait until tomorrow to chat. I apologize. Thanks for your super chat. But apparently people can't behave, so that's the way it has to happen. You should just be subscribed all the time. Yeah, it's like hi Kelly Reed. I hope you had an amazing birthday. Yeah, it's like an over-the-counter strainer and it adjusts to your sink. I don't know, we can pull it up and look at it. Hopefully we're going to be in the right courtroom. 16029. Is anybody on the ground there? Skybell says, I'm so glad to find you. My daughter, 23, loves you. So do I. Oh, that's nice. We span all the generations, Skybell. Thanks for hanging out for 10 months. And Melanie's interruptions this year. Best 11 months of my life. Melanie's interruptions. I know. I get sidetracked. I don't know. Do I have ADD or something, or ADHD? Am I just like going around from topic to topic and I get interrupted by the chat? Not interrupted, but distracted. How was the concert? Thanks, Kimberly. I think this crossed this crossed. They did submit an opposition, and we read it yesterday. So you can go into the, actually, I linked it in the show notes below this video, and it should take you exactly to the timestamp where we went over the opposition. And the opposition is, yeah, it's in Dedham. It's in Norfolk Superior. It is, see, Melanie's Interruptions. That's such a great username. The opposition said, listen, you've had her phones for over 18 months. And the most recent case law from end of August said that something like 123 days was too long, and you've had it for something like 500 and something days. And so absolutely you should not be able to search her phones at this point. And Common Sense for Sale, Carla, gifted a membership. Thank you. Appreciate you. And so we are just waiting. We're waiting, and we're staying out of the drama. So hopefully you're staying out of the drama too. Somebody said to me, oh, here we go. If you are on the court Zoom, please mute yourself.
Number 8. Okay, welcome to all on Zoom. This is courtroom 25 in Norfolk Superior Court. Please remain on mute. Thank you very much.
Folks, just check the cell phones, make sure the windows are off, please.
He's waving to me. Are you waving to me, Aiden? Hi, Aiden.
Isn't it? Oh, Amanda's standing in for Emily.
Oh, we see you.
We are ready for Judge Krupp.
Am I the only one streaming this? Because maybe he is watching.
Not like that.
I know there's a lot of Melanies. We were all born in the 60s probably, right? Remember? I got a brand new pair of roller skates. You got a brand new key. A lot of Melanies here.
And there's another arraignment, Attorney Gavigan, with a Spanish interpreter in lockup.
Margaret. Margaret's the court clerk. Did we love Margaret so much?
Lucy, you're first.
That was a good
We'll put up the green
Thank you.
hashtag. Since we have Aiden on the camera, on screen, and he's got a green curtain behind him.
Mr. McBean's next date. Oh, no, when's his next date?
Well, it's the 17th, and then I got an email from the ADA that she was hoping it could be put 12 to noon rather than 2.
We'll be on trial, so I can't.
All right, everyone, please.
Pick a different date.
Now we're going to make a change. Remind everyone, make sure your cell phones are off. Away.
Afternoon.
Afternoon.
We're going to start with number 8. This is Jermaine McBean, 25 CR 27. Mr. McBean is present along with his attorney, Paul Carlucci. Amanda Mullaney is standing in for Emily Farley. The parties could please identify themselves for the record.
Good afternoon, Your Honor. Amanda Mullaney for Emily Farley.
Okay, and good afternoon, Your Honor, Paul Carlucci on behalf of Mr. McBean.
Okay, thank you for standing in. I heard this a couple days ago.
Sure.
I issued bail conditions, and we need to make sure Mr. McBean is in agreement with those conditions and understands the consequences of violating them.
Mr. McBean, the court orders you to recognize in the sum of $500,000 cash with the following conditions. GPS.
Not $500,000 cash.
50,000. I'm sorry. 50,000. I read the surety. I apologize for that. $50,000 cash with the following conditions: that you undergo GPS monitoring before release with home confinement, reside with your cousin at 65 Clifford Street in Hyde Park, Massachusetts, remain in Massachusetts, and stay away and no contact, direct or indirect, with the victim. Do you assent to those conditions, sir?
Yes.
And you're hereby notified if you post this bail on a charge of the crime during the period of your release, your bail in this matter may be revoked in accordance with Mass General Law, Chapter 276, Section 58. Your next date, which I hear might have an issue.
It's 10/17. It's scheduled for 2 o'clock, so I guess that's where it sits right now.
Okay. If there ends up being a problem with that, you'll let us know.
Right, I think there is a problem with 88 Farley, but we haven't resolved that yet.
Okay, we'll leave it on the 17th.
Your matter is continued to October 17th at 2 p.m. for trial assignment. You will be transported on that day if you haven't posted bail.
Thank you.
Sir. Okay. May we take the return of the
Sure.
jury? Please approach sidebar.
Yeah.
Okay, they muted. Mark is on the stream too, I saw, but he doesn't have his camera on. So I don't think Aiden's attorneys are going to argue this because it's really Karen Reed's attorneys who have standing to argue this, and they've submitted their opposition, which we read yesterday. And I don't even know that Cosgrove has the standing to make this motion anymore with his current status of Aiden Carney's case being stateless because...
Next before the court, number 10, Commonwealth versus Evan Wilson, 25 CR 105. Mr. Wilson is present and represented by Attorney Robert Nelson. The Commonwealth is represented by Assistant District Attorney David Ominu. The matter is on for filing of motions. The parties could please identify themselves for the record.
Good afternoon, Your Honor. David Armand for the Commonwealth.
Okay, Mr. Amanu.
Robert Nelson for Mr. Wilson.
Okay, Mr. Nelson. Has certificate of compliance been filed?
Yes, Your Honor.
Okay, great. And are there motions to be filed? All right, so we just need to set this up for a trial date?
We're actually going to ask for a lobby date if we could.
Okay, we can do that.
The second week in November, if we could.
Sure.
there are a lot of other cases on, so we have to sit through some cases. But we like to do that because
They're
we like
looking
to see
Go ahead, sorry.
the treatment of the court to other defendants other than Aiden Carney. Krupp is the one who originally threw Aiden in jail, right?
The 13th of November will be available.
Okay, 13th of November for a lobby?
Mr. Wilson, your matter will be continued to November 13th at 2 p.m. for a lobby conference. Thank you.
Thank you.
Okay.
Oh, I just lost my next one.
Thank you, Your Honor. Thank you, Madam Clerk.
All right.
Thank you. Next before the court. Number 3, Commonwealth versus Antonio D'Souza, 23 CR 130. Mr. D'Souza is present and represented by Attorney Edward Swan. Commonwealth is represented by Assistant District Attorney Amanda Mullaney. Matters on for filing of motions. If the parties could please identify themselves for the
Good
record.
afternoon again, Your Honor. Amanda Mullaney for the Commonwealth.
Okay,
Good afternoon, Your Honor. Attorney Edward Swan for Mr. D'Souza.
all right.
Do you want me to take your other motion?
Mr. Kirk, could I pass that?
We love Margaret, the court clerk that's in there today. She showed us all the bingo balls when she picked the alternates in Turk's case.
Okay, so I have the motion to express statements. Have you seen this?
Yes, I was just
Attorney
given it.
Mullaney, you just given it. It looks like there probably needs to be an evidentiary hearing.
No, this is under Aiden's case number. Don't be confused.
How many witnesses do you think you would need?
I would anticipate just one, Your Honor.
Just one?
Yes.
Okay. Half day, a 2-day, half morning, a 2-hour hearing?
I would anticipate calling Dr. O'Loughlin, and that could be maybe longer than might be a full morning or a half day. I guess I have a hard time predicting where it might go.
Okay. Dr. O'Loughlin has submitted something here. Let me just find it.
I guess attachment 4 is his expert report.
Let me see that. So my assumption is you would move the admission of the expert report subject to cross-examination. And it would be relatively brief, direct, and then the Commonwealth would have an opportunity to question him about the report, presumably. Are you thinking of more than that for the evidentiary hearing?
I just hesitate to say it would be brief. I don't know exactly.
I'm just trying to understand how you would be thinking about the hearing when it comes to Dr. O'Loughlin's testimony.
Yeah, so he, as Your Honor either has seen or already knows, he did a series of tests and evaluation, reviewed the video, audio of the examination, the interrogation, and would opine on all of that to the extent needed. I don't want to overstate it. I just didn't want to understate it and stand here before the court trying to squeeze more in than the time was allotted. So, I think you're right. It could be a fairly brief direct examination, half hour maybe.
Okay. All right. So let's see if we can find a morning when we can do a couple hour suppression motion.
We had discussed December 12th.
December 12th?
Yes, and I was trying to be mindful of the availability of Dr. O'Loughlin.
How would December 12th be for an evidentiary hearing in the morning?
I'm looking it up right now. That is great.
All right, you hit the jackpot.
Thank you.
All right, December 12th for an evidentiary hearing.
Jackpot.
Okay. I would like to get any response to the motion from the Commonwealth in advance. So if you could file whatever you want to file by, doesn't need to be much in advance, but by the 9th or 10th, that would be great. Okay, thank you.
Your Honor, if I may, I filed 2 ex parte motions for funds, and that is supplemental funds for the work that Dr. O'Loughlin has done. I can explain if the court would like explanation or.
I will take a look at these when I get off the bench and act on them, and based on what you've given to me. Okay?
Yes?
Very good. Thank you.
Thank you.
Mr. D'Souza, your matter is continued to December 12th at 9 a.m. for hearing on your motion to suppress. An interpreter will be requested.
And I apologize if I may just clarify the court. Mr. D'Souza does require a Portuguese interpreter for anything of substance to convey to him today. I will make use of Google Translate, give him that further date, and I have prepared him for what we have done so far, that it was not substantive.
All right, very good.
Thank you.
Thank you, Your Honor. Thank you, Madam Clerk.
Next, before the court number 2, Commonwealth versus Jacob Shields, 2006 CR 847. Mr. Shields is present, represented by Attorney Neil Madden. The Commonwealth is represented by Christopher Mead. I believe it's on a motion to seal. You could identify yourself for the record.
Christopher Mead on behalf of the Commonwealth. Good afternoon, Your Honor.
Good afternoon.
Neil Madden, Mr. Shield.
Okay, Mr. Madden, I took a look at the motion to seal. Is there any opposition?
Your Honor, the Commonwealth would oppose the motion to seal on that it is under the test on a pond, that there isn't sufficient, he hasn't shown sufficient cause. I understand it was a case, it was no pros back in, I think it was 2009. One of the things in the motion mentions that it was unfounded. In reviewing the no pros, the letter attached, I don't think that's, the Commonwealth did no pros the case, but it was because based on information that was provided by the Department of Children and Family relative to the victims at the time, and as far as whether, how the trial would, the effect, how it would be detrimental for them to go through that. That mentioned at the time, I believe Department of Children and Families had custody of the children, of the victims in the case. I understand the defendant has filed a motion and does make mention of partially why he's seeking that, the motion to seal. I would say that there isn't, as far as sufficient cause, particularity of more information about the steps he's taken since this case, as well as the steps he's taken to try to get involved in the activities he mentioned in his motion.
All right.
I just suggest that this happened today, it would be sealed immediately. Mr. Shields was in a tough relationship with a woman that was 6 years older than him, had 2 boys.
Preach.
He took a sentence for 2 years because of assault battery charge against her. He gets out early, he's at a halfway house, and these charges all come down on him. There's absolutely no basis for them. He adamantly denied them from the beginning. He's been living with this. Now, even as I talk to him in the hallway, you can see he's been living with this, and it's been painful. He's moved on. His wife is here, the head hunter, Allison. He's now got his own business. They live in West Rochester. They have 2 young children. And he just wants to be able to go out in the community and coach and do other things and fill out query forms. and, because these things hang around in his background.
Okay.
And,
All right. I'm going to take a look at PON again, and the standard and, take it under advisement.
Now, if it's possible.
Yes.
I don't think the court can do it, but can you seal the Quincy ones too, since they were really part of this case? That's.
I don't think I can, seal, cases in another court.
Yeah.
So if it was originally charged in Quincy and then brought here on an indictment, you'll have to go to Quincy to get it sealed. You might want to wait for an action by
Call
me
O'Keefe
on this
hand
motion
signals.
before you do it. Okay? Okay, very good.
Matter is taken under advisement. Thank you. Next before the court, number 11, Commonwealth versus Dwayne Anderson Jr., 25 CR 128. The AAG might be out in the hallway just because it was so crowded. Attorney Gavigan, can you?
Oh, it's
Would
crowded.
you mind calling them in, or? It's for appointment of counsel also.
Okay.
Hearing with counsel. So Mr. Anderson is present. Duty Attorney Jim Gavigan is here, and along with Assistant Attorney General Alicia Willis. If you could all just identify yourselves for the record.
Good afternoon, Your Honor. Alicia Willis of the Commonwealth.
All right.
Attorney James Gavigan, I'm the duty attorney today, Your Honor.
Okay, Mr. Gavigan.
Your Honor, Raymond Saig. I filed my motion as a result of the request by Mr. Anderson.
Okay. Do we have that motion? All right. Thank you. Okay, Mr. Saig,
I don't wanna
I'm
make
going to
him laugh,
allow your
but,
motion to withdraw and appoint Mr. Gavigan.
Thank you, Your Honor.
We haven't seen Jim, the court clerk, lately. Where's he
Mr.
been?
Gavigan, have you had an opportunity to talk to Attorney Willis about the case?
Yes, I have, Your Honor.
Okay. What do you think is the appropriate thing for us to next schedule?
Just a pretrial conference, Your Honor. I just want to review the material, speak to the defendant, Your Honor. And is my understanding that the defendant resides out of state in Ohio. We're asking either that he can appear by Zoom on the next date or that his presence be waived, Your Honor, either or.
Okay. Any problem with Mr. Anderson appearing by Zoom?
That's agreeable to the Commonwealth, Your Honor.
All right. So we'll pick another date for a pretrial conference, and Mr. Anderson, you can appear by Zoom. All right. What date would you like?
December, an early December date that might be available to court, the 2nd or the 3rd or the 4th of December.
3rd?
We could try that, Your Honor. I have a trial the week before Thanksgiving that will most likely run into that week. If we could do December 10th, that would be easier on my schedule.
December 10th at 2 p.m., Your Honor.
Okay, great.
Thank you. And I'm sorry, we did try and confirm dates, but it was a little hectic earlier.
No problem.
So Mr. Anderson, Attorney Saig has been allowed to withdraw. Attorney Jim Gavigan has been appointed to represent you. With this appointment, there is a legal counsel fee in the amount of $150. Your matter is continued to December 10th at 2 p.m. for a pretrial conference. You are able to Zoom if, Attorney Gavigan, if you just email me the day before, I can send you the Zoom information. Yes, or the same one for this courtroom.
Okay.
Okay. Thank you, sir.
Thank you, Your Honor. Thank you, Madam Clerk.
Okay.
3 o'clock in the church, but she's tied up in the main until 3 p.m.
Okay, thank you so much for that. So Mr. Gavigan, will you be able to help us on that arraignment and lockup? Thank you so much. Okay, we do have some probation matters we can do. Mr. Gavigan, you're ready?
Yes.
Or sorry, Gavin Flanagan, sorry. This will be number 6. No, number 5. Commonwealth versus Vladimir Cellphone, 23PT32. The parties could please come forward and identify themselves for the record.
Good afternoon, Your Honor. Gavin Flanagan, probation.
Okay, Mr. Flanagan. Where's Mr. Sylvain? Mr. Sylvain. Okay, good morning.
Good morning.
Afternoon, I guess. Afternoon. So the violation here is a new case out of Stoughton, operating a motor vehicle with a suspended license.
Yes, Your Honor. And I did bring, it was on the 9th, that I did
hand you up from the R&B on the 9th of that night. I guess there was fees that weren't paid. He did pay that night. The case was dismissed the next, the arraignment date.
Okay.
So just, and, he did take the initiative. He emailed me that night, everything that was on there, so.
All right. I appreciate you bringing this to my attention. Is there any reason I shouldn't just dismiss the probation violation?
No other reason, Your Honor.
Okay. I'm going to dismiss the probation violation, and you'll be subject to continued probation on the same conditions. Okay?
Oh, I
you.
like that he's
Very good.
dismissing
So
some
then the
probation violations
is
today.
dismissed,
That's a good
And
sign.
you are discharged on probation with the same terms and conditions. Thank you, sir.
Is he in a dismissing kind of
Next,
mood?
before the court, number 6, Cumwell versus Michael Cote, 23 PT 122. Mr. Cote is present. Mr. Gavigan, are you helping us with this? Okay.
Thank you.
Or, oh, it's just a motion to travel? Yes. Okay, with probation officer at Kia Brantley. Did I give you this or no? Is there a written motion?
Yes, I came to Your Honor. Good afternoon, Your Honor. Kia Brantley for probation.
Okay. Let me just take a look. I have a written, handwritten request by Mr. Cote. How do you say, is that how you say your last name?
Cody.
Cody? Cody. Okay, bear with me 1 second.
There's a lot of cases on the 2 o'clock calendar. So we're going to get to hear them all, but he's in a dismissing mood today. He just dismissed someone's probation violation, so it's a good sign. Don't be confused. They filed the motion under Aiden's case number, but it's for Karen
What does
Reed's
it mean
phones.
to drop trailers? What is that? What do you do?
Well, I haul a lot of festival trailers to the festivals, drop them and leave, and then go get another one, bring
We
it
like
back. Usually
festivals.
about 3-4 trailers to a festival. And then I go and get them when the festival's over, but it dries up around September. So I've been getting a lot of calls to do stuff out of state.
And how far how far do you have to go?
Sometimes I get calls to Alabama, Mississippi, Texas, Florida.
All right. You're currently under conditions that allow you to travel to New Hampshire, Maine, and Rhode Island for work, provided that you tell the probation officer the day before. Yeah. Okay.
I mean, Judge, he's bringing us our festivals. Come on now. We need a music festival.
Ms. Brantley, is there any reason that I shouldn't allow Mr. Cody to travel more broadly?
No, Your Honor. Mr. Cody has been in compliance. He fulfilled all his terms of probation. I have been his probation officer since his release in April of 2023. We did come before the court, I believe it was in 2023, in regards to the traveling within New England. He has complied with those. There hasn't been any issues. The person that he hauls the trailers for has contacted me as well to verify basically what Mr. Cody was saying and their need. Apparently he's very good at what he does, so he seems to be highly sought after. So probation doesn't have any objections as long as he contacts me before he leaves and lets me know where he's going and when he comes back, he needs to contact
That sounds reasonable. All right, so I'm going to permit travel within the continental United States.
He's being reasonable today.
With prior notice to probation on the same type
is
of
it carnivals?
free notice. That
Is
is
it
to
carny?
say, you'll let the probation officer know the day before, let her know how long you'll be gone. Okay. If you want to prepare new conditions, I'm happy to sign them. What I'm going to do is I'm going to endorse. I don't think we've docketed this letter request from Mr. Cody, but I think what I'll do is we'll docket it. And I'll endorse it as allowed.
We're rooting for everybody
as we've
today.
described in open court, and I'll sign new conditions for you.
Yes, Your Honor.
Okay.
Thank you.
It's funny that
Motion
he's
is
a carny
allowed,
and this is Aiden Carney.
Remain on probation with
right?
all the other same terms and conditions.
There are no
Good luck, sir.
coincidences. Remember that.
Attorney Gaffney, have you heard from Attorney Angelatas? That's number 12, Calvin Cantave. Have you heard from Mr. Angelatas?
Oh boy, he better show up or they're going to send a warrant. They're going to send the marshal to pick him up.
Couldn't take him. It was
Oh.
continued to today to try and get him an attorney.
Okay, so Mr. Gavigan, we have another case for you.
Ms. Brantley?
He is in lockup, Mr. Calvin Cantave.
Just giving out
Sorry, I didn't-
defendants today.
Cantave. I'll try to print out the docket when I have a moment. Do you want to give him any information that you can? Sure. Thank you. So second call on number 12.
Okay.
Thanks, Aaron.
So we're still waiting on Attorney Bradel. We do have the plea on Mr. Bao that
Where's Bradel?
got canceled, but then put back on the list.
Oh, I didn't see it on the list, so it's definitely going to go?
It was
Okay.
an error by our office.
All right.
So I printed out the docket. Do you want to do that?
And we have the arraignment too.
We need to finish interpreting.
Oh, we need the interpreter for that, okay? Sure.
Margaret's taking
Okay,
control of that
so,
courtroom.
Next before the court, Commonwealth versus Japheth Bao, 24 CR 199, a custody. Have you done a waiver?
Not yet.
Oh, okay.
We have to lobby the case.
Oh, I'm sorry. Okay. So if you could just identify yourselves for the record.
Good afternoon, Your Honor. Gordon McLeod for the Commonwealth. Good afternoon, Your Honor. Dan Mitchell on behalf of Jeff Baugh.
Okay.
He's fine. Everybody stop worrying about Aiden. He's
Yeah.
fine. And by the way, telling someone they look tired is not a compliment. Why do people feel like they can just
let me see at the sidebar.
insult men? Like it's not a big deal. It's not a compliment. He's fine. Thanks, Fairy Raven, for gifting a membership. And yeah, not Aiden having a Zoom be Dr. Turtle Boy. That thank you for your Just a Watcher for your super chat, and Fairy Raven for gifting a membership. Sandra from Canada pointing out that Krupp never interrupts the Commonwealth, but always interrupts the defense. Thank you for your opinions. Great time to point out that my viewers' opinions are not necessarily my opinions. Laura says, didn't Brennan try something similar when Karen's team suddenly marched into one of Aiden's hearings? That was wild. Yes, we did. And I have an Instagram reel that is set to the song of When the Saints Go Marching In. Karen's team was in the basement watching YouTube and found out that the hearing was going on upstairs under Aiden's case number to get, I forget what they were trying to get at that time. They were trying to get communications, I think, between Karen and her attorneys. And Brennan looked real surprised when they marched in, but the court officers were like pulling out the chairs for them to all sit down, making room. That was fantastic. Karen gave Brennan the death stare. It's on my Instagram. Check it out. I think they're going to do Aiden's case last, but it's really for Karen's cell phone. So here's why you're confused. It is docketed today under Aiden's case number, but this is Karen Reed's motion to argue because Karen Reed doesn't have any case numbers anymore because her case is over. She's been acquitted. And so when Cosgrove made this motion for a taint team to go through Karen's phones that they've had since January of 2024, he made it under his search warrant number. So it's out there floating in the Ethernet until they've assigned it to Aiden's case number. And that's why it's under Aiden's case number. He's on Zoom. He doesn't need to be there in person because he doesn't really have standing to argue this motion. Karen's attorney, Steve Buzang, has opposed it. I don't know if he's there, but I'm assuming they're going to call this case last so that they can get rid of all the other defendants because some of them are in custody. And the only people left in the courtroom would be people that are there for either Karen Reed or Aiden. I don't know. Are any supporters there on the ground today? I saw Scott McGinnis on Justice Served TV, and I guess it was a clip that they released this morning. You did a great job, Scott McGinnis. And Scott McGinnis says, I like to stay outside. I don't like to go into the courtroom. I like to stay outside. He's like, and I was there yesterday for Kelsey Fitzsimmons. He says, I didn't even bring my signs. And they were mad. That judge on Kelsey Fitzsimmons yesterday in Salem was ready to do her trial next week because I mean, it's weird because he's so mad about all the attention this case is getting. And it was not Judge McCarthy Naiman. It was wild. I don't know. Maybe Bradel was had to fly to to Salem for an emergency hearing because the judge said so. That was crazy yesterday. If you didn't see that, go back and watch it from yesterday. It was I think my morning stream yesterday. I think we did two yesterday, right? Hi, Emily C. You're about to drive by where? Salem Courthouse or the Dedham Courthouse? Why don't you go on in there, Emily, and then you can call me, and then you can come on and tell us about your observations. I'm waiting for you to do like a diary entry about everything that happened yesterday. Emily, you got to keep that diary going because we love your diaries. Emily kept us entertained during the Karen Reed trial too, with her Hank Brennan diary entries and Adam Lally diary entries, and we laughed for a long time. How dare you? Says, where in the world is Timothy Bradle? I don't know. He might have something else in the bill. You know, hey, here's, you guys need to understand. Lawyers have a lot of clients, a lot of court appearances. You may have something else in the building and you're just in another courtroom and then you come in and I wouldn't worry about it. I'm sure he's who knows where he is. I'm sure he's on his way. Aurora Ora says, I took the day off for this. Really? Oh, girl. Well, I mean, I'm glad that you took the day off. Happy 15-month anniversary to us. But you may be disappointed because it may be just quick. We'll see. Shine on you, crazy diamond. Thank you for tuning in from across the pond. As you know, big fan from Germany here. I send you an email with a merchandising idea. I really hope you like it. Thank you. I will check it out. But because your username is probably different than your email address, I don't know if I'll be able to correlate the two. But I have received a lot of emails lately about people with merch ideas. So I'll take a look for it. Thank you very much. And for your super chat. Hayden Stylist is working. Yes. The stylist is working. She's doing a great job. Thank you, Kimberly, for your Venmo. Says, love your show. Free Turtle Boy. His Turtle Boy's Defense Fund link is pinned in the chat. Thank you, Scott Messerschmidt, for putting it in there. And I pinned it. If you have, if you care about the First Amendment and you're interested in freedom of speech and other things such as like that, and you want to help a guy out, good legal representation is not cheap, you guys. It is not cheap. And I'm sure that every dollar is appreciated. If you are able to, please donate. Who's beeping? It is the beeping for the court. It is the Zoom beeping. And Zoom beeps when the court is muted. And there's nothing I can do about it. Although it does sound like we're in a hospital. It sounds like some sort of monitor in the hospital. And really, we're all on life support, aren't we? It's like this entire courthouse is on life support. Norfolk County itself is on life support. And so the beeping is completely appropriate, in my opinion. Just saying. All right, Wendy Taylor, you are all set. We're all on. Elaine Burris, thank you for your very generous about Venmo. Says, thank you for avoiding the drama and for keeping our efforts on target. You are the best. No, Elaine, you are the best. And I got another interesting email from a viewer that I may just read without telling you who she is, because she kind of speaks for, I think, a lot of us who are just like, I don't know, you're in your feelings. A lot of you are in your feelings. I don't know, Just Irish, why this keeps happening, but maybe you don't curse in the chat. If you're cursing in the chat, just don't. Thanks. YouTube doesn't like it. But I fixed it again for you because you've been blocked like 4 times in the past 2 days. So it's really easy to not get blocked. Just don't be a jerk. Don't write dirty words in there because YouTube does scan the chat for AI. A lot of creators don't care about it. I do because I have a lot of parents who watch with their kids in the room, and I have a lot of like doctors' offices that watch on their big TV in the waiting room and stuff like that. So we're just trying to be appropriate at the very least. They still have not called the case yet, so we're waiting through the rest of the calendar, and that's what we're doing. We're seeing how Judge Krupp is treating other defendants, and he just basically dismissed someone's probation violation. So hopefully he's in a dismissal mood today. Wouldn't that be nice? I think that would be nice. Oh, all right. She said, hey, Melanie. I'm not going to out her. You're the only one I can say this to that would understand. I'm missing the old days when Reddit was posting about bus stop people or when juror number 1 was a Nazi. How many of you have been with me? If you've been with me since the Maya Kowalski trial, you understand that reference. Just put a 1 in the chat. And she said, what's happening right now has really hurt me. I briefly spoke to my husband about it. He said I felt betrayed, and that's the word for it. I think a lot of people do. So here's the thing. For those of you who have followed me since the Maya trial, can you just put a 1 in the chat? Because I got a text message from Dr. Joe Corcoran yesterday, and he said to say this to you guys. I'm not sure if you've heard or not, but juror number 1 from the Maya trial had a massive heart attack last week. He needed to have open heart surgery and has been dealing with a series of significant complications. He's been in the hospital for more than a week and is about to get transferred for the 3rd time. He says, I'm now helping his wife, Yoli, to navigate him to get the best care. Please ask your audience to keep him and Hippo Lover in your prayers. Thanks, with the prayer hands up. So if everybody could please just put some prayer hands up for juror number 1 from the Maya Kowalski trial. Remember how he got dragged back into court and they tried to get his cell phones and his wife's cell phones because his wife was named Hippo Lover and she was apparently participating in some LawTubers chats and other creators chats about the Maya Kowalski trial, and it was wild. Yes, juror number 1. So thank you guys. And Dr. Joe started a channel. I don't know if he's still broadcasting or if he's still putting up any videos, but very sad what happened to juror number 1. That was a Florida case. That whole case was very sad. There's been a lot of appeals about the verdict and stuff. And what was the amount of the verdict in the end? It's like over $260 million for Maya and her family. Yeah. I don't remember now. That was a long, long, long time ago. Oh, Dr. Joe. Oh, he stopped posting? I didn't know about that. Chelsea. So that is very sad. 260 million. I was right, Gabby. 240, 260. Sandra says 240. I mean, if the fake Karen Reed is here because somebody did change their name to Karen Reed just to show how easy it was to change their name, just try not to chat today because they're going to block you because people are going to think that you're the real Karen Reed and we know you're not. So we don't need any drama or any sort of pulling focus away from what we're here for today. Oh, look at Blessed Mom from Texas. We love you, turtle boy. Final settlement, Corn Pope said of $213.5 million, but it wasn't the amount up on appeal. So I don't know. I know it got reduced. Thanks, Kimberly, for becoming a new member. I think you have to wait a certain time before you can change your name back. And I think that was the problem. I think you have to maybe wait 2 weeks. Thanks, Kimberly, for becoming a member. Thank you, Patriot Biker, for being here for 5 months and for saying another great live stream. Thank you, Mel. We got over 10,000 people in here today. So, it'd be so cool is that if all 10,229 of you would hit the like button because it helps the girl out, helps the algorithm. And also will be great if you would hit the subscribe button because that is free. And we're on a quest to get to 130,000. We're almost there. We're inching up. Thank you, Patriot Biker. Deborah says, I may have missed it, but how did this hearing get attached to Turtle Boy's docket? Because it's the docket number that is remaining. I really don't know how, because Cosgrove filed it under a search warrant number. He didn't file it under a docket number. Karen's case is closed. It's over. She doesn't have an open case. So I don't know how it got attached to his docket. I'm confused about it too, but it is under his docket number, but it is Karen's attorney's standing to argue. However, if Cosgrove is conflicted, I don't know what's going to happen today. It could just be tossed or kicked until if and when Michael Marcy is able to appoint another special prosecutor. No, he's not allowed to because he's conflicted because Lindsay Gattani, because Lindsay is going to be the one that burns the whole house down. Lindsay is going to burn the whole house down, and she may be, in the end, the reason that Aiden's charges get dismissed. And we've talked about that several times because she's telling them everything. Apparently, she's got tons of dirt on Jen McCabe, and she's just willing to give it away. Well, she's not really giving it away because I think it's behind a paywall on Substack, but she's willing to talk about it. So thanks, Deborah, for your super chat. Mary Malarkey, thanks for gifting a membership. And email subject is simply merchandising, and my name is Jasmine. Thank you. Thank you, Sean, on your crazy diamond. Clinton Nix, can you explain why the judge blamed Bradel for court phone issues? Yes, I have no idea. I know. Here's what I can tell you. that these Salem courts, I guess, are not used to all of this publicity, and maybe they don't want people knowing what's going on in their county. And maybe Kelsey Fitzsimmons' case is getting a little too much, public interest because you guys need somebody else to free. And so you've pivoted to Kelsey Fitzsimmons because regardless of whether she pointed her weapon at herself or, even the cop, what they're doing to her is horrible. What they're doing to her is absolutely horrible. She should not be treated the way she's been treated. She didn't even violate her conditions. So the fact that she was thrown in jail for 180 days, which is, in my opinion, a violation of the Americans with Disabilities Act, because courts have to, abide by that as well. And she has a disability because, she was shot in the chest at maybe point blank range. She's got a collapsed lung. She's had 6 surgeries. She was in the hospital for 53 days. She's got bullet fragments in her chest, a lacerated liver, and other things. Because she's unable to blow into that thing, the judge threw her back in jail instead of just letting her pee in a cup. Why judge blamed Bradel for phone? I have no idea. They were like, yeah, you're really straining our technology because we have 10 people on the party line. It was like a party line. It was like a conference call. Like you had to call the phone number. It wasn't Zoom. And he was really in a pissy mood, that Judge Dreckler, or I'm not even sure how you pronounce his name. And apparently it was straightened out because I think Bradel got an email yesterday saying this is going to be a phone conference and he didn't want to throw the clerk under the bus. And that is why eventually they heard it by phone instead of forcing Bradel to drive from wherever he was to Salem in October traffic. I have no idea. But eventually they did figure out how to add some more slots to their conference call. Because, it's Salem. They're still in 1692, apparently, with their technology. Let's help Turtle Boy out. Donate to his defense fund, please. Free Turtle Boy. Thanks, Bridget. Free super chat. And for reminding people that the defense fund is pinned in the chat for those of you who need it. Well, the judge decided on the cell phone issue today. I really dislike the long waits for decisions. Thank you, Scorpion. Let me just pull out the magic 8 ball because this magic 8 ball is going to have as much of a chance of answering your question as I will. And it says it is certain. Well, I don't know. I don't know if it's going to be certain, but I would never bet on what these judges in this courthouse are going to do ever. And so I don't know. I mean, it sounds like an easy call for me. If the most recent case law, the most recent precedent is from end of August 2025 that says 123 days to hang on to something is too long. It sounds like a slam dunk to me, but what the hell do I know? All right, we're back. Thank you, Scorpion.
Next are for the court numbers 4, 7, and 9. Hummel versus Aiden Carney.
Here we go.
23 CR 313, 24 CR 43, 25 CR 88. If Mr. Carney joins us via Zoom, if the parties could please identify themselves for the record.
Good afternoon, Your Honor. I'm Robert Cosgrove for the Commonwealth.
Okay, Mr. Cosgrove.
Hello, Your Honor. Timothy Bradel for Mr. Carney. Good to be with you.
Okay.
Good afternoon, Your Honor. Attorney Steve Buzang on behalf of Ms. Reed.
All right, let's deal with Mr. Buzang's matter. I'm not sure.
Is he going to hear more than one motion?
That it's necessarily, well, I guess it's denominated 24SW0004. But it really is a request for setting a set of conditions for searching through Ms. Reed's phone under a protocol that would assure against the sharing of privileged information. It seemed to me that the Commonwealth's request and Ms. Reed's response spoke completely past each other and didn't address the merits of each other's papers, which is why I felt like I needed a hearing. As far as I can tell, the phone has already been downloaded, searched in terms of what the court authorized previously, and it just hasn't been looked at yet, and it has to be looked at subject to a particular protocol. Do I have that right, Mr. Cosgrove?
I don't know if it has actually been downloaded, Your Honor.
How do you not know? How do you not know?
If it hasn't been downloaded, that's a set of facts very different from what I understood to be the case. Because I think I authorized the download, and I thought that there was a representation in the papers that it had been within the days of the authorization. Let me just see if I can find it in the papers.
You may have, well, okay.
I don't think he ever authorized that. Of Karen Reed's phone? I don't think so. I don't think he's ever been involved in any of Karen Reed's motions, has he?
I think the representation is that the phones were seized pursuant to authorization. I don't think, and I don't purport to be much of an expert on the technical side, that the download can take place absent access to the phone through a password, which would have to take place relevant to the search protocol.
If the cell phones have not been downloaded pursuant to a prior order, that raises all the various things that Mr. Buzang presented in his opposition, which is the Commonwealth having been positioned.
I'm flipping to the live feed.
Papers. You may have, well, okay.
I've got the live feed from WCVB, so we're going to watch this instead, and it should be exactly where we left off. Sorry, Turtle Boy. We like your face, but we want to see Cosgrove.
I think the representation is that the phones were seized pursuant to authorization. I don't think, and I don't purport to be much of an expert on the technical side, that the download can take place absent access to the phone through a password, which would,
Can't hear it.
Would have to take place relevant to the search protocol.
In your motion, the Commonwealth's motion, it says on January 22, 2024, the Commonwealth sought a warrant.
Now we're back to this
for
one.
mobile devices capable of communicating in cell phones used by Karen Reed. After review, Krupp authorized the warrant. I am paraphrasing. Next paragraph. The search was executed on January 24, 2025 at 14:45 hours by Lieutenant John Fanning, who filed a return of service indicating seizure of 2 Apple iPhones, 1 purple with green case and 1 white with clear case. Is that seizure only of the phones, or is it the download of the information contained in the phones? Let me just see. I thought that there was something in here that said that there was a download, but maybe I mistook that.
If there's something in there that I picked up from an affidavit or a previous filing, I don't know, but my understanding is that the phones were seized.
Phones were seized and they haven't been searched.
No,
they haven't been.
And they can't be searched absent access to the phones, which require either the Commonwealth proceeding with breaking the attempting to break the log-on information or the receipt of the passcodes.
Okay. Well, so you've been in possession of the phones since January of 2024, and are only now requesting leave to download the information and search the phones.
No, I think we already have leave to download the information pursuant to the warrant. What we have is the practical impossibility of downloading the information. What we're seeking is leave to do the search pursuant to a search protocol. As I understand it, Your Honor, there are two aspects to this. One is the physical seizure of the phone, for which the SJC has imposed prompt requirements to get a warrant after the phones are seized, or in this case, there was a search warrant issued prior to the seizure of the phones. And the second aspect is the second search warrant to search the information. I don't think there's any basis for parceling out downloading as kind of a middle step here with a separate requirement.
Well, what do you say to Ms. Reed's argument, Mr. Buzang, that there's a certain amount of time you have to download if you have the phones, and now more than a year has passed, and it's only now being requested?
Well, there's no question that more than a year has passed, and it's only now being requested. And if Ms. Reed is right, I think that would be dispositive. But I don't think there's any basis in the case law for concluding that Ms. Reed is right. The case law suggests that a warrantless search of cell phones, if that takes place, the Commonwealth must promptly seek a warrant, and the burden of justifying any delay is on the Commonwealth, whether or not the defendant presses for the return of the phone. That rule is designed to protect the defendant's possessory interest in the phone. And that, as I understand it, is based, among other things, on Segura versus the United States, 468 U.S. 796. Now, this case is not a warrantless seizure. It's a seizure pursuant to a lawfully issued search warrant. There are instances of items that have been seized in evidence that may have been subjected to tests years after the fact, sometimes as a result of new evidence or developments in a case. But where a warrant is obtained, the usual and accepted procedure, which so far I've seen no evidence that the SJC has changed, is that the Commonwealth retains the seized items until the conclusion of the case, which time the defendant may move for their return or the Commonwealth may move for other disposition. That's generally General Laws, Chapter 2. Items that have been seized in evidence that may have been subjected to tests years after the fact, sometimes as a result of new evidence or developments in a case. But where a warrant is obtained, the usual and accepted procedure, which so far I've seen no evidence that the SJC has changed, is that the Commonwealth retains the seized items until the conclusion of the case, which time the defendant may move for their return or the Commonwealth may move for other disposition. That's generally General Laws, Chapter 276, Sections 3 through 8. Now, I've looked at the cases that Mr. Buzang has cited.
And Diaz relates to a warrantless seizure of the cell phones and a delay in seeking a warrant to search?
Yes.
Okay. And here we have a warrant that authorized the initial search of the cell phones. Let me ask Mr. Buzang why that isn't dispositive. Is there a case that talks about a circumstance where there is a warrant that is issued to authorize the seizure of the cell phones, which is then where the ultimate search, the contents of the cell phones is delayed and therefore somehow prejudicial to the defendant and is suppressed?
I think, Judge, in this case here, the phones were seized January of 22nd, 2024.
Right, pursuant to my warrant.
To your warrant, exactly,
Right.
Judge. and nothing's been done. The only reason something.
I understand, but do you have a case that says that when that's the circumstance and a year plus passes, they can't come back to the court to seek authorization to go into the phones when the court has originally authorized the seizure of the phones in the first place?
Well, I think Diaz, Judge.
Well, Diaz didn't involve a warrant, apparently, for the seizure of the phone. It was a warrantless seizure of the phone. No judge had viewed the contents of that phone as potentially, or had ruled that the contents of that phone were potentially evidence in a case, right? That there was probable cause or a basis to issue the warrant. So the question is whether you have a case that results that arises in the context of a warrant authorizing the initial seizure of the phones, and then there's a delay in looking at the content of the phones or any other piece of evidence. You know, warrant authorizes the seizure of hiking boots, and there's a 1.5 year delay on doing DNA testing to see if the blood, if the boots trudge through mud or blood or whatever the relevant substance is.
Sure, Judge. Well, I feel that the reasonableness in delays in obtaining a search warrant under the Fourth Amendment and Article 14 of the Search and Seizure Law requires law enforcement to act diligently to obtain a search warrant without unreasonable delay.
And here they did by seeking a search warrant for the seizure of the phones. The question is whether there's an independent, any case says that there's an independent obligation to seek further warrants authorizing looking at other aspects of the phone besides seizing the physical phone itself in a timely way.
Well, I think timing is relevant, Judge. They could have done it. They could have done it with the special counsel Mello. He chose not to. He went into the grand jury, which they returned a no bill. And Your Honor, this court knows better than anybody the level that requires an indictment to get issued. Here, they returned a no bill, Judge. I mean, there was less than any evidence that Ms. Reed conspired with Mr. Kearney to intimidate or participate in any intimidation of any witness in this case. But I think it is relevant in terms of now they want to come back and look at her 2 phones, and they have all that evidence from Mr. Kearney. They have, I think,
all right, no, I understand those arguments, but I'm still trying to find a case, if you have one, that comes up in the context of a warrant authorizing the initial seizure of the device, and then there's a delay in searching that device or searching that physical piece of evidence.
Just give me one moment, Judge.
Sure.
Bradel's trying to help him. Braille's giving him a little bit of advice now. He's whispering into his ear if you're not looking at the phone.
You know what? I don't have a case off the top of my head, Judge, but I think just going back to the reasonableness under the Fourth Amendment, I think again, this I don't think would have came up if we just let it stay and didn't ask for the 2 phones. It was only after I asked for the 2 phones that now this is somehow an ongoing investigation. When they've had the investigation was done, and there was nothing to it. If they had, and I think with this evidence, Judge, that they have, they can go back to 10 grand juries. They're going to get 10 no bills. But okay. I think in terms of reasonableness and timeliness, Judge, I think, it's almost 2 years.
Okay, I'll take it under advisement.
And the matter, it does have a next date of December 5th.
Oh, you know what? I'm sorry, Margaret. I didn't get to the issue of if the warrant issues for the search of the phone, do you have any contest with the protocol that was set out by the Commonwealth?
I do, Judge. I don't think the Commonwealth, in the preventive medicine case, the defense has some say in, who would be a part of the taint team. So I don't take the representation from the government that they should just set it up.
I don't have any opposition from you or any substantive response to you for the with regard to the protocol that's proposed by the Commonwealth. That was part of the frustration that I had with the papers as they came to me.
Crossing over, I understand, Your Honor.
Yeah, so there's a elaborate protocol laid out here in the Commonwealth's papers, and I need specific details as to what you're proposing if I'm going to authorize the Commonwealth to search through the two phones. I take it you can make a backup of the phones and do the search off the backup, and you can promptly return the phones to Ms. Reed.
I assume that's the case, Your Honor. I will check.
Okay.
But
He has no
before we get to that,
standing.
Judge, could I just have a couple of weeks to provide some opposition to that? It'll be
Opposition to what?
to the taint team.
Opposition to what? They've suggested a taint team that is totally connected to Proctor and Brian Albert and Marty Kraft. This is wild.
Part of the
What?
provide some opposition to that. It'll be
Opposition to what?
I'm sorry,
to
what?
the taint team part of the government's motion.
No. You can talk to Mr. Cosgrove. The two of you folks can talk and come together, come to an agreement as to a protocol. And if there
The taint team is tainted. How do I know that and they don't know that?
are any disputed paragraphs or sentences in that protocol, you'll show them to me in a document indicating that there's a disagreement as to this or that and the reason. Not a long brief, okay, not an elaborate briefing, but if I'm going to allow this, there's going to be a taint team protocol put in place. And I assume you're going to agree to 95% of what the Commonwealth is proposing, and you may quibble around the edges. I've issued these before, okay? It's not all that complicated. So, I'll give you 10 days to do that. If that gives you folks enough time to confer with the idea that you'll reach agreement on most of it.
Very good, Judge.
Any problem with that? Okay, is that enough time?
No, that's fine, Your Honor.
Okay.
Always happy to talk to Mr. Boothson.
All right. I think there'll be very few things for me to resolve. So I'll give you 10 days. That'll be, what are we? We're already October 8. How about if you get it to me by the 21st, October 21st?
Good enough, Judge. Thank you.
And I'll take it in Word form so that I can make whatever edits I feel like I need to make to your version, taking one side's or the other's version. I'm likely to be more like a baseball referee, is take the version that I think without, fiddling too much with the language. So both sides really need to be reasonable.
Understood.
Okay, 1021.
Okay. So, we'll await your responses. You have until October 21st. And the matter's next on
Thank you,
December
Your Honor.
5th.
Thank you, Madam Clerk.
Thank you. At 2 p.m. for hearing on the motions to dismiss. Thank you. I'll see you then.
Your Honor, may I be heard on the disqualification issue?
Mr. Bradel, in what docket did you file a motion for disqualification?
Judge, I believe that was filed in all three dockets. This one is styled as an in-ray search warrant docket. It's 20, I have it right here, just 1 second.
When was the motion for disqualification filed?
I believe last week.
October 6th.
10-6? I'm not going to hear you on that until I get a response.
Sure, I understand, Your Honor. It's just a little bit cart before the horse, I think, because counsel is forging ahead under a conflict. And, I don't think counsel for the Commonwealth should be permitted to keep forging ahead on this thing until the conflict issue is resolved. So I would ask that you stay any action on the part of the Commonwealth.
I will not.
Until we,
I will not. I'll put you on for a hearing on a motion for disqualification. But I'm not going to do it on the fly or without everybody having adequate opportunity to be heard.
Sure. I understand. Your Honor.
When would you like to schedule a hearing on that motion? Margaret, do you have? We could do December 5th, but do you have the motion for disqualification? I have an affidavit.
Sorry, Judge, there's an impounded and a redacted one. Redacted for the public docket, and there should be an unimpounded one, or unredacted one, rather. That's for the court. And I believe they were filed in all three of those dockets. Well, the 24 and the 23 case for Mr. Carney, and this in-ray search warrant case. And if not, I'll just make sure Madam Clerk has them in this case, but. Sure.
The files are so voluminous.
Okay. What's the status of the 2025 case?
The,
25 CR 88.
that's had a little bit of a background.
That's the window intimidation case because they're hearing other motions now on Aiden's case. So this really was for Aiden's case because they have 3 of his cases on the docket today, all 3 index numbers on the docket. This is wild. I paused it because we can do that on YouTube, thankfully. Holy, catch your breath, everyone.
Judge, I think there's a pretrial, where it's in the pretrial phase right now in terms of discovery.
All right, but there's no disqualification motion filed in that one.
Correct, Your Honor.
Okay.
That's correct. The 24 case on the part of Mr. Carney, Mr. Cosgrove acknowledged and withdrew. The 23 case we contend
I'm sorry.
Sorry.
Say that again.
Sure. The 24 case on the part of Mr. Carney, that's 24-0043.
Yeah.
Mr. Cosgrove has acknowledged and withdrawn from that case, and I believe he's got a couple more weeks to confer with the district attorney and provide some sort of a replacement. The 23 case, we have now moved to disqualify him as for the same exact reasons why that apply in the 24 case, in the sense that Ms. Gattani is suing him and is also a key witness in the 23 case by the government's own admissions. The detective on the case swore to it.
Yeah, that's fine. So you haven't filed a motion to withdraw on the 2025 case.
Correct.
Okay, so we'll take up the 2020. We'll put all the cases on when it's an appropriate time to do a hearing.
Sure.
So when would you like to do the hearing?
Judge, could we do it a little before December 5th in November at some point? And if we can't get a date right this second, can we report?
Oh, you can get a date right this second? Okay. We'll figure it out.
Sure.
December looks better to me than November, Your Honor. And part of the problem I have is that in moving to disqualify me, particularly since Mr. Bradel has, or Mr. Kearney has moved as well to disqualify the Norfolk County District Attorney's Office, is who should respond to the motion to disqualify me? Should I respond? Should or can the Norfolk District Attorney's Office respond, or should it?
What you should do is just resign right now. Recuse yourself. You know it's valid. You know you have to step away. Just recuse yourself right now. Just say, Judge, I consent, and speed this thing up. This is wild.
Be the Attorney General or someone else. So there are discussions underway as to who the appropriate person is to respond to that, and I expect it will take a little bit of time to hash that out.
Okay. We have a hearing date, December 5th?
We do, Your Honor.
On the mega,
All right.
on the mega motion.
It should be here. Yeah. What? No.
I will move it.
Yes, it should be in this session, December 5th.
Very good.
Okay. And that's at 2 o'clock?
Yes.
Okay.
Thank you.
So, Mr. Carney, your matter is continued to December 5th for a hearing on the motion to dismiss and the motion to disqualify at 2 p.m. Thank you.
Thank you.
Both
Thank
on the
you,
same
Your
day?
Okay.
That makes no sense at all.
May we have Mr. Cantave?
Look, Bradel's going to be pissed. Hold on. The Zoom is over too. Bradel's going to be pissed.
Goodbye.
10-6.
I had to take a phone call from a doctor, so I had to get off for a second. So I want to rewind it because I missed a part. We're in the inside out, upside down Narnia of Norfolk County, Massachusetts, and Judge Krupp is the fresh hell that we are absolutely enduring today. This is wild. Okay. We all know that there is an unwaivable conflict for Cosgrove, for Michael Morrissey's entire office, because Lindsay Gattani has sued Cosgrove and she's suing Michael Morrissey. So because Lindsay Gattani is going to be a witness in all of the cases, except for the window intimidation case, they must step away from this case. They must. There's no option here. So by hearing both the mega motion on December 5th and the motion to withdraw on December 5th, how is anybody going to oppose the mega motion? I don't know. Has Judge Krupp not been watching my coverage or what is going on or anybody's coverage? Like what? This is insane. I need to take it back. I don't know, maybe 5 or 6 minutes. Maybe 7 minutes. Hold on. 8 minutes. Hold on. This is the man that is deciding the future of Karen Read. He's going to allow it. He's going to allow a search of those phones. I believe he's going to allow it. This was WCVB. They were broadcasting it thankfully on YouTube so I could boost the volume. But let's go back a little bit and so I can listen this time. Hold on.
I do, Judge. I don't think the Commonwealth, in the preventive medicine case.
This is Steve Buzang. He's the attorney for Karen Read that is representing her with the very narrow issue of getting her property released. He made a motion to get the Lexus back. He made a motion to get the phones back. And as a result of the motion to get the phones back, that's when Cosgrove filed this motion for the taint team, which we can look at again after this because I just pulled it up. Brado's pissed.
The defense has some say in, who would be a part of the taint team. So I don't take the representation from the government.
Got to go back even a little bit more. Hold on.
Right, no, I understand those arguments, but I'm still trying to find a case, if you have one, that comes up in the context of a warrant authorizing the initial seizure of the device, and then there's a delay in searching that device or searching that physical piece of evidence.
Just give me one moment, Judge.
Sure.
And this is where Brado's helping him out, whispering in his ear. I got to find that most recent case. Wasn't that a case that they had the phone for 123 days and they never got a warrant to search it or whatever the property was? That is on point.
I don't have a case off the top of my head, Judge, but I think just going back to the reasonableness under the Fourth Amendment, I think again, I don't think would have came up if we just let it stay and didn't ask for the two phones. It was only after I asked for the two phones that now this is somehow an ongoing investigation. When they've had the investigation was done and there was nothing to it. If they had, and I think with this evidence, Judge, that they have, they can go back to 10 grand juries. They're going to get 10 no bills. But okay. I think in terms of reasonableness and timeliness, Judge,
right. Why is Doolin off this case? Because Doolin seemed to get it. Krupp is the guy who put Aiden originally back in jail, right? Or in jail for the first time, right?
I think, it's...
That one did not have a case.
Okay, I'll take it under advisement.
And the matter, it does have a next date of December 5th.
You know what? I'm sorry, Margaret. I didn't get to the issue of if the warrant issues for the search of the phone, do you have any contest with the protocol that was set out by the Commonwealth?
He's absolutely going to allow it. He's going to allow it. I told you we're not out of the woods yet. We're not in the clear yet. That's why all of his nonsense going on out there in social media helps no one. No one.
I do, Judge. I don't think the Commonwealth, in the preventive medicine case, the defense has some say in, who would be a part of the taint team. So I don't take the representation from the government that they should just set it up.
I don't have any opposition from you or any substantive response to you for with regard to the protocol that's proposed by the Commonwealth.
That's right.
That was part of the frustration that I had with the papers as they came to me.
Crossing over. I understand, Your Honor.
Yeah. So there's a elaborate protocol laid out here in the Commonwealth's papers, and I need specific details as to what you're proposing if I'm going to authorize the Commonwealth to search through the two phones. I take it you can make a backup of the phones and do the search off the backup, and you can promptly return the phones to Ms. Reed.
I assume that's the case, Your Honor. I will check.
Okay.
But before we get to that, Judge, could I just have a couple of weeks to provide some opposition to that? It'll be
opposition to what?
Opposition
to the taint team part of the government's motion.
No. You can talk to Mr. Cosgrove. The two of you folks can talk and come together, come to an agreement as to a protocol. And if there are any disputed paragraphs or sentences in that protocol, you'll show them to me in a document indicating that there's a disagreement as to this or that and the reason. Not a long brief, okay, not this elaborate briefing, but if I'm going to allow this, there's going to be a taint team protocol put in place. And I assume you're going to agree to 95% of what the Commonwealth is proposing, and you may quibble around the edges. I've issued these before. Okay, it's not all that complicated. So I'll give you 10 days to do that.
I've done this before. I've allowed this before. You know, we didn't pin it on the girl last time, but you can bet your hell or high water we're going to pin it on the girl this time.
That gives you folks enough time to confer with the idea that you'll reach agreement on most of it.
Very good, Judge.
Any problem with that? Is that enough time?
No, that's fine, Your Honor.
Okay.
I'm always happy to talk to Mr. Boozing.
All right. I think there'll be very few things for me to resolve. So I'll give you 10 days. That'll be, what are we? We're already October 8. How about if you get it to me by the 21st, October 21st?
Good enough, Judge. Thank you.
And I'll take it in Word form so that I can make whatever edits I feel like I need to make to your version, taking one side's or the other's version. I'm likely to be more like a baseball referee, is take the version that I think without, fiddling too much with the language. So
no, a baseball referee would be calling balls and strikes, and what you're doing is an abomination of the Constitution. This is why I call Massachusetts the place your constitutional rights go to die, because apparently they can seize your phone and hold on to it for a year and a half, and then decide later on, after you're acquitted of your first charges, maybe they want to try again and acquit you of some and try and convict you of some more charges. And so now we'll search your phone to see if we can find some different information to maybe pin something on the girl, because we can't just let the girl get away scot-free with a year's probation and a little bit of a couple $100 fine. We need to pin something on the girl that's going to stick. So let's get in there and see if we can find some felony charges so that we can really pin it on the girl to protect maybe some of the higher ups in the government, or, some really powerful people like the family. It's wild, you guys. This is not how it should go.
both sides really need to be reasonable.
Understood.
Okay.
Oh, no, you need to be reasonable. Maybe the reasonableness should come from the judge. You're not a baseball umpire. We need Dexter. Thank you. We need Dexter. Here. There you go. Motion granted.
Okay. So, we'll await your responses. You have until October 21st. And the matter's next on
Thank you,
December
Your Honor.
5th.
Thank you, Madam Clerk.
At 2 p.m. for hearing on the motions to dismiss. Thank you.
Frida's like, hello.
I'll see you then.
Your Honor, may I be heard on the disqualification issue?
Mr. Bradel, in what docket did you file a motion for disqualification?
Judge, I believe that was filed in all three dockets. This one is.
Hello?
Hello. Hello, I'm here.
I mean, sometimes you need Cardi B. Are you kidding me? Oops.
Ray search warrant docket. It's 20. I have it right here. Just 1 second.
When was the motion for disqualification filed?
I believe last week.
October 6th.
10-6. I'm not going to hear you on that until I get a response.
Sure, I understand, Your Honor. It's just a little bit cart before the horse, I think, because counsel is forging ahead under a conflict. And, I don't think counsel for the Commonwealth should be permitted to keep forging ahead on this thing until the conflict issue is resolved. So I would ask that you stay any action on the part of the Commonwealth.
I will not. I will not. I'll put you on for a hearing on a motion for disqualification. But I'm not going to do it on the fly or without everybody having adequate opportunity to be heard.
Sure. I understand.
When would you like to schedule a hearing on that motion? Is that Margaret, do you have? We could do December 5th, but let me, do you have the motion for disqualification? I have an affidavit.
Sorry, Judge, there's an impounded and a redacted one. Redacted for the public docket, and there
I
should
mean,
be
so the
an
bottom line is everything is going to be
unredacted one, rather. That's for the court. And I believe they were
Heard on
filed in
December 5th.
all three of those dockets. Well, the 24 and the 23 case for Mr. Carney and this in-ray search warrant case. And if not, I'll just make sure Madam Clerk has them in this case, but
I think they might be downstairs because I didn't think.
sure.
The files are so voluminous.
Okay. What's the status of the 2025 case?
The
25 CR 88.
That's had a little bit of a back burner, Judge. I think there's a pretrial where it's in the pretrial phase right now in terms of discovery.
All right, but there's no disqualification motion filed in that one.
Correct, Your Honor.
Okay.
That's correct. The 24 case on the part of Mr. Carney, Mr. Cosgrove acknowledged and withdrew. The 23 case we contend
I'm sorry.
Sorry.
Say that again.
Sure.
Okay, so I think we can stop it there. Everything is coming back on December 5th. Ishmael says we need to stay on the issue. The issue is this court still wants to F around. They need to find out. We can either fight each other or fight these toxic, corrupt people thinking that they can do whatever they want. Yeah. And that's exactly what I said, that girl, TT. Cosgrove should be recusing himself, not waiting for a decision on that he's going to take under advisement. And God knows how long it's going to take for that. Let me go back with you now. For those of you who may have missed the stream where we went over Cosgrove's initial motion, we're going to look at it again right now because I'm going to show you what exactly it is that he's looking to do. And he's not even the proper person who should be doing this. This is the weird motion that we looked at because it was filed under a search warrant number. It was not filed under Carney's docket number. And there's not even a caption here. The caption would be the case name. It would say Commonwealth versus Aiden Carney. There's nothing. It's blank. Okay. Everyone who's an attorney or a paralegal or who works in a law office, their head is popping off right now because this is how it was filed. Okay. Under a search warrant number, no docket number, no case name. It's insane. And it's called the Commonwealth's Motion for Examination of Digital Material seized from Karen Reed pursuant to search warrant issued on January 22, 2024. The motion itself is 9 pages. But what they were asking for, let's go to the end when they ask for here's what they wanted. Even though they've had the phones since January of 2024. So let's not confuse this, okay? Karen is first arrested January 29th of 2022. On the date of her arrest, they seized her phone on January 29th of 2022. Remember when they went to her parents' house in Dighton and they towed her car without a warrant and they seized her phone without a warrant? And then they didn't even have a warrant to seize. Then they finally get a search warrant to search that phone. That is when in August, Proctor is texting his friends. Like, I'm going through the crazy whack jobs phone right now. No nudes yet. Okay. That's in August of 2022. Because she was arrested again in June when they upgraded her charges to murder of 2022. And then in 2024, I think it was Tully and Fanning who pulled up to up Karen's driveway. Because remember, she was never incarcerated. She was out on bail the entire time. I think it was like $80,000. She had a post or $100,000 that was eventually reduced to 80 so she could have some money to pay her attorneys. In January of 2024, Tully and Fanning, I think, you can correct me if I'm wrong, pull in her driveway with a warrant. They're like, we have a warrant to seize your phones again. And I think, and you can tell me if I'm wrong, did they seize 2 phones the second time in 2024? So they had already downloaded the first phones that they seized, remember, in January of 2022. Now they had more phones from January 2024, which would have had all of her communications between January of 2022 for 2 years, right? And January 2024. So they sit on those phones and they had a warrant to seize them, but they never got a warrant to search them because you need two separate warrants, one to seize and one to search. Even though they went to a grand jury to try and indict the ham sandwich of Karen Reed and Aidan Carney on conspiracy to intimidate witness charges in, I think, March or April of 2024, they didn't have a download of Karen's phone. All they had was, I think, one witness, right? And was it Tully? Refresh my recollection because everything is conflating in my head right now. But they had no cell phone evidence. And the grand jury refused to indict, refused to return a true bill. And that case just died. And then Karen's team, her defense attorneys for trial number one, because remember, this was before trial number one, did not find out that this grand jury had been convened and declined to return a true bill until after trial number one was over, which is also wild to me because that evidence of that grand jury would have been discoverable. It should have been automatically disclosed before trial number one. Am I insane? Am I losing my mind? Because it's very possible that it could be. So in addition to hiding all the Sallyport video, having all of this magical mystery Sallyport video just revealing itself after trial number one, that was then hidden, according to Judge Cannoni, in a drawer by, was this Natalie's testimony? I thought Natalie didn't testify in front of, I thought that the conspiracy grand jury had one witness and it had no cell phone extractions and it was one witness. And I think it was only Tully. I'm remembering correctly. Okay. All of the magical mystery Sallyport video that turned up after trial number one, that according to Judge Cannoni, Michael Proctor hid in a drawer. And that's the reason that they didn't need an evidentiary hearing because, no big whoop. She's getting another trial. So there's no prejudice. They're so corrupt. They're so corrupt. This is not how the justice system is supposed to work. This is not how defendants are supposed to be treated. You're supposed to be innocent until proven guilty. And the Commonwealth is supposed to be looking for the truth, not a conviction. Kiss your rights goodbye in Massachusetts because you don't have any. You don't have any. I don't know if Kay Willis, the realtor, is here, but if you need one and you want to get the hell out of Massachusetts, get the hell out of Massachusetts. Wow. So here's what Cosgrove wants, and he really has no standing to make this motion because Lindsay Gattani is the key witness in the conspiracy to commit witness intimidation charges because Lindsay Gattani is the one who told Tully that Aidan and Karen were communicating and that they used Signal and that Natalie was involved and that then Karen, was communicating with Aidan and like maybe gave him, addresses of the witnesses. And so they were conspiring together to intimidate the witnesses. Okay. And so Lindsay is a material witness in that case. There's no getting around it. And because Lindsay Gattani has sued Cosgrove and is intending to sue Michael Morrissey, they are both conflicted out because their interests do not align. Because Cosgrove will try to prove that Lindsay is a liar in the case against him, and Michael Morrissey will try and prove that Lindsay is a liar in the case against him. And yet they're going to be trying to vouch for her credibility in any case involving Aidan and Karen conspiring to commit witnesses. Do you see how that works? Do you see how that's not a conflict that is waivable? No, it's not just Massachusetts, but we happen to be covering a lot of Massachusetts cases and we happen to be seeing it quite a bit in Massachusetts. So, I mean, here's what the Commonwealth proposes with regard to the taint team. They just really want to just search her phones and find all of the new evidence that they now want to convene a new grand jury because apparently you're allowed to do that in Massachusetts. Convene another grand jury with new information. And so Cosgrove says, yeah, we know we've had the phone for a really long time, but here's what we want you to do. And Judge Krupp seems like he's willing to do it, which is wild. Commonwealth proposes the following taint team forensic search procedure for the search of communications and data located on Karen Reed's cell phones. Yeah, so there's more than one phones seized pursuant to the above entitled search warrant. Number one, the taint team will consist of a special master, an appointed forensic examiner who has not been and may not be involved in any way in the investigation or prosecution of the defendant presently or in the future. And here's who they're suggesting. And remind me, Stephen Verino of MV MVWV, Multimedia Forensic Investigative Services. Well, somebody looked this up. MVW, Multimedia Forensic Investigative Services, is that Marty Kraft's company also? So Marty Kraft is a guy who's like a retired Boston PD, who's now a private investigator, and he may or may not employ Kate Peter, Brian Albert, and Michael Proctor, right? Thank you. Thank you, 3 Clerk Monty. The taint team is tainted, okay? They're on the same board. No, it's not, it's a different, they have a different company together? Well, I don't know. Somehow they're related. And then they want retired district court judge Joseph Macy to be the special master. I don't think anybody's even made the connection in papers between Verino and Marty Kraft and Brian Albert and Michael Proctor. The family roots, the family tree, the roots of the family tree in Canton are so twisted and they're so deep. The tentacles run so deep. Marty and the other guy, Verino, serve on the board for the PI Association. I don't know. Somebody sent me some corporate documents and I just don't know where they are right now. Thanks, Clemasus. And so Mr. Verino already served as the appointed forensic examiner to search Aiden's phones, which they said they never searched, but really they did. They're willing to pay for the taint team, the Commonwealth is. And then within 14 days of the court's order, counsel for Ms. Reed shall provide to the court search terms to facilitate the taint team's identification of attorney-client privileged information. Free Judge Doolin. Where is Judge Doolin? I think he was transferred to civil court. Remember last time he said you might not see me next time? We need Judge Doolin back. He gets it. So they're going to give us all the search terms, and then they're going to give us all the passwords to access the devices. Or you can plead the Fifth. If she claims the Fifth Amendment privilege, the Commonwealth may file a motion to compel her to provide the information sought, according to some case law. And then if there's any issues, then we can come in for a hearing. You know, you can sift out the privileged information, but aside from that, we're getting it. We want everything. And it sounds to me like Krupp is going to allow it. Okay, thank you, Glamasus. They are both serving on the nonprofit Licensed Private Detectives Association of Massachusetts. I mean, it sounds to me that he's going to allow it. I wish I could help you make sense of this, but I can't. I don't think it's ever going to end. It's never going to end. Let's go to the chat. There's a lot of questions. Sharon said, didn't they get the phone under Karen's case? That's closing. They should give back the phone now, correct? Thank you, Sharon D. This was from, I don't know, half an hour ago. Technically, they got the phone under a case that did not yet exist originally. And so there was no docket number filed originally because there was never a true bill returned. So there was never an indictment. Are you picking up what I'm laying down? And so that's why they filed it under that original search warrant number. Thanks for your super chat. Tracy says, so now Karen can plead the Fifth. Careful what you wish for. But they could come in for a hearing and then they could force her to give the passwords. Bridget said, I'm stressed. This is crazy. I poured a peach margarita. Recuse yourself, doofus. Cosgrove, duh. Thank you for your 5. Pro Gamer, please explain. The warrant was issued in Karen's case, right? Technically, it was going to be a different case. I think I just explained this. Has she been accused of something else? No, but what they want to do is go back to the grand jury with new information, which would be the download from her phone if they find anything that they think they can use, and try and get her on conspiracy to intimidate witness charges. That is what they tried to do. It didn't work. So now they want to get what's on her phone and try and do it that way. Her attorney argued, number one, anything that's going to be found in her phone, you already have because you have Aiden's phones. That was his first argument. The second argument was there's a new case that just came down that said holding on to something for 123 days without searching it is too long. And in this case, they've had it for 500 and something days. So it's definitely too long. So this is like phones number 2 and 3. They got her first phone in January 22. These are 2 new phones from January 24. Can warrants be used for different cases than ones they were issued for? With the grand jury, no bill. WTF. I wish I could explain that to you, but I can't. I just can't. And then why they put it under Aiden's case number, I have no idea, because there was no case number, because they're stateless and case numberless. Andrea Alexander, if Karen files her suit against the Commonwealth, figures they mentioned in the civil suit, would that create a conflict for this search warrant issue? No, I don't think so. She sues the state of Massachusetts. Well, she said she was going to sue the MSP, Tully, Proctor. I mean, I think the Lindsay Gattani issue is enough to say that there's a conflict. So I don't think we need to look any further than that. As in, they need to find someone else to search. Well, I mean, this is the taint team that they're asking for, the same taint team that they used in Aiden's case. So it's not the Commonwealth that's searching the phones. It is a specially appointed taint team. Hope that answers your question. Thanks for your 10. And at the end of the day, John O'Keefe was not hit by a car. A car did not hit John O'Keefe. So guess what? Something else happened to him. Somebody else murdered him, or there was some kind of an accident that happened somewhere, and then maybe a dog got involved. But John O'Keefe was not hit by a car, and a car did not hit John O'Keefe because medicine and science and physics. And so if John O'Keefe did not get hit by a car, and Aiden Carney has been accusing other people of participating in or trying to cover up the murder of a Boston police officer, John O'Keefe, isn't that just journalism? And really, isn't Karen Reed allowed to talk to any journalist that she wants to? There's nothing wrong with that. And at what point do the witnesses turn into suspects in any type of case, in a general fashion, generally? We were talking about this the other day, back in the 70s when 60 Minutes was the thing, and how people were right in Nixon's face calling him a crook. It's wild. It's wild. This breaks my heart, says Dee. She's praying. Thanks, Dee. Marcello from Argentina says, Krupp lets the Commonwealth do anything. They will indict Karen Reed and Turtle Boy with another crooked grand jury. Karen Reed still has 8 months probation left, and Turtle Boy's out on bail. They will try to lock them up once they get the indictment. You might be right. Your dad says, I want people to be forewarned. People like Kate Peter will be blasting content that they claim comes from Karen's phones. Don't fall for the tricks. Thank you, Marcello. Kyle says 25 minutes behind. Any court in Massachusetts that's not corrupt? I don't know, Kyle. You tell me. We've seen some good judges. I like Judge Doolin. We like Judge Halal. Remember Judge Halal? He was the judge on, which case did Judge Halal try? Turk? Remind me. Lindsay Tyler says plenty of case law to support her argument. Commonwealth v. McCarthy, Commonwealth v. Sion, Commonwealth v. Green, Commonwealth v. Dwyer. The one that they cited that just came down August 29th, and this is interesting, is Commonwealth v. Diaz. And that was the one that said 128 days was too long. Thank you for giving me those other citations. But what I just did was I pulled up this case. And let me just show this to you, because this is the Appeals Court of Massachusetts. And check this out. I have it pulled up, so I kind of want to take a quick read through it. I don't want to cold read it with you right now, but this was the one that was decided August 29th of 2025. And look who the judges are that decided this. There's a Judge Neyman, Neyman. I mean, is that a common last name? Because the judge in Kelsey Fitzsimmons' case that sits in Salem, her name is Judge Kathleen McCarthy -Neyman, spelled the same way. N-E-Y-M-A-N. Coincidence? I don't know. Thank you, Lindsay Tyler. I'm gonna check these cases out later. You know who's really good at checking out the case law is Brother Counsel. I give Martin all the props. He looks up case law. He explains it. He's very good at that. That's what he does. I never have time because I'm always on the fly with you guys. So here's what this case was about, this Diaz case. The Commonwealth appeals from a Superior Court judge's order allowing the defendant's motion to suppress evidence obtained from a search of the defendant's cell phone. This case requires us to consider whether the judge committed an error of law in concluding that a 123-day delay between the seizure of that cell phone pursuant to a lawful search incident to arrest and the application for a warrant to search the contents of that cell phone was not reasonable under the Fourth Amendment to the U.S. Constitution. Isn't that exactly what we're talking about here? Am I missing something? They had a warrant to seize Karen's phone, but they didn't have a warrant to search it. Am I wrong? Did they have the warrant to search and they just never executed it, or they just never appointed a taint team? Sounds on point to me, right? Is the judge not understanding this Diaz case? Did Buzang not argue Diaz? I mean, this is the case. I have it right in front of me. Look, August 29th, 2025. But Buzang cited this in his papers, so why didn't he rely on Diaz? Because you need two warrants. You need a warrant to seize, and then you need a warrant to search. It's two different warrants. But Crystal Justice says the Commonwealth had a warrant to seize and search. This case didn't search. Judge is saying that Diaz doesn't apply because he, Judge Krupp, signed the warrant to seize the cell phone. And the search of the phone isn't bound by the time after a lawful warrant to seize. But that's exactly what this case says, right, Zoe? I mean, I'm not crazy, right? Hold on. Because he did say something at the beginning of that hearing that we need to go back and listen to. Hold on. Let's go back to the hearing for a minute. Because now I need clarification. Because we want to get it right. Let's take this down. Let's put that back up.
Access to the phone through a password.
Hold on. I think it was maybe closer to the beginning. And we were on Zoom, so we didn't get to see Cosgrove. So here we go. They're gaslighting us, okay? Thank you, Crystal Justice, because
but all right, let's deal with Mr. Buzang's matter. I'm not sure that it's necessarily, well, I guess it's denominated 24SW0004. But it really is a request for setting a set of conditions for searching through Ms. Reed's phone under a protocol that would assure against the sharing of privileged information. It seemed to me that the Commonwealth's request and Ms. Reed's response spoke completely past each other and didn't.
All right, Lindsay says Diaz didn't have a warrant to seize. They had an arrestable offense to seize and then didn't apply for a warrant for 120 days. Well, I want to hear what the judge says too. Thanks, Lindsay, for pointing that out. I guess you read the case.
Address the merits of each other's papers, which is why I felt like I needed a hearing. As far as I can tell, the phone has already been downloaded, searched in terms of what the court authorized previously, and it just hasn't been looked at yet. and it has to be looked at subject to a particular protocol. Do I have that right, Mr. Cosgrove?
I don't know if it has actually been downloaded, Your Honor.
If it hasn't been downloaded, that's a set of facts very different from what I understood to be the case. Because I think I authorized the download, and I thought that there was a representation in the papers that it had been within days of the authorization. Let me just see if I can find it in the papers.
You may have, well, okay. I think the representation is that the phones were seized pursuant to authorization. I don't think, and I don't purport to be much of an expert on the technical side, that the download can take place absent access to the phone through a password, which would have to take place relevant to the search protocol.
If the cell phones have not been downloaded pursuant to a prior order, that raises all the various things that Mr. Buzang presented in his opposition, which is the Commonwealth, having been in possession of the phone for an extended period of time, has a finite amount of time in which it can seek authorization to search or to do the search. Let me just see for a second.
This was the part that I missed when I had to take that call. So I'm glad we're listening to it again. Thanks, Lindsay Tyler, for coming in with all the deets on the sitch. Yeah, I think he was the judge on the Brennan shenanigans, wasn't he? Wasn't it Krupp?
Yeah. So in your motion, the Commonwealth's motion, it says on January 22, 2024, the Commonwealth sought a warrant for mobile devices capable of communicating in cell phones used by Karen Reed. After review, Krupp authorized the warrant. I am paraphrasing. Next paragraph. The search was executed on January 24, 2025 at 14:45 hours by Lieutenant John Fanning, who filed a return of service indicating seizure of 2 Apple iPhones, 1 purple with green case and 1 white with clear case.
It was halal? I don't remember. Sisitsky?
Is that seizure only of the phones, or is it the download of the information contained in the phones? Let me just see. I thought that there was something in here that said that there was
Thank you. Sisitsky. Thanks, Mary Raven.
a download, but maybe I mistook that.
If there's something in there that I picked up from an affidavit or a previous filing, I don't know, but my understanding is that the phones were seized.
Phones were seized and they haven't been searched.
No.
They haven't been.
And they can't be searched absent access to the phones, which require.
Yes, she can sub in a different lawyer, Emily.
Proceeding with breaking the, attempting to break the logon information.
Yeah, jailbreak the phone because they didn't have the password.
Or the receipt of the passcodes.
Okay. Well, so you've been in possession of the phones since January of 2024, and are only now requesting leave to download the information and search the phones.
No, I think we already have leave to download the information pursuant to the warrant. What we have is the practical impossibility of downloading the information What we're seeking is leave to do the search pursuant to a search protocol.
Yeah, the taint team.
As I understand it, Your Honor, there are two.
Thank you, Lady Zelda, for gifting.
There are two aspects to this. One is the physical seizure of the phone, for which the SJC has imposed prompt requirements to get a warrant after the phones are seized, or in this case, there was a search warrant issued prior to the seizure of the phones. And the second aspect is the second search warrant to search the information. I don't think there's any basis for parceling out downloading as kind of a middle step here with a separate requirement.
Well, what do you say to Ms. Reed's argument, Mr. Buzang, that there's a certain amount of time you have to download if you have the phones, and now more than a year has passed, and it's only now being requested?
Well, there's no.
The more I listen to this, the more I feel like I'm being gaslit. Thank you, Beagle, Rescue Mom, for gifting 5 memberships. Sorry that I'm making you guys listen to this again, but I need to listen to this again because I'm trying to make sense of it for you. Which I could do on my own time, but it's so much more fun to do it with you because, you know, you're very collaborative.
No question that more than a year has passed and it's only now being requested. And if Ms. Reed is right, I think that would be dispositive. But I don't think there's any basis in the case law for concluding that Ms. Reed is right. The case law suggests that a warrantless search of cell phones, if that takes place, the Commonwealth must promptly seek a warrant, and the burden of justifying any delay is on the Commonwealth.
Yeah.
Whether or not
what's your justification for the delay?
Presses for the return of the phone. That rule is designed.
They wanted to put her in jail before her trial. That's obvious, right? That's why they did this before the first trial, but it didn't work. So now that she's been acquitted, I feel like they're just grasping at wet paper straws. I would usually say straws, but wet paper straws are my pet peeve. And so they're grasping at wet paper straws, desperate to get them. And Aiden has said there's not going to be anything in those phones. But then some alleged audio leaked of an alleged phone call between Karen and Aiden where Karen's yelling, "Do you have any idea what's in my phones?" That somebody leaked. And this is why I starred this comment for later, because this was such a great comment. Dom said, "Yes, Mel, 100%. All the drama has made this so much worse. Everyone should just have kept quiet and not discuss this matter on social media." Listen, there's a lot of people out there that want to rage bait you and become agents of chaos. And that's what's happening here. And it's all very suspicious timing, don't you think? Sounds like malicious prosecution to me, Lauren. Sure feels like it, doesn't it? Nona to 3. Thank you for gifting 5 memberships also. You guys are amazing. Thank you, Bridget, for reminding people to hit the like button.
To protect the defendant's possessory interest in the phone. And that, as I understand it, is based, among other things, on Segura versus the United States, 468 U.S. 796. Now, this case is not a warrantless seizure. It's a seizure pursuant to a lawfully issued search warrant. There are instances of items that have been seized in evidence that may have been subjected to tests years after the fact, sometimes as a result of new evidence or developments in a case. But where a warrant is obtained, the usual and accepted procedure, which so far I've seen no evidence that the SJC has changed, is that the Commonwealth retains the seized items until the conclusion of the case, which time the defendant may move for their return or the Commonwealth may move for other disposition. That's generally General Laws, Chapter 276, Sections 3 through 8. Now,
Okay, so riddle me this, chat. Riddle me this. Here's the original search warrant application by Tully. I'm going to show you because it was an exhibit to Cosgrove's motion. This is the original search warrant application that Tully filed January 24th of 2024. And it says right here in paragraph 2 of this, 31-page warrant, this application for search warrant is to seize the devices only. And seize is all in caps and bolded, as described below. And remember, this search warrant affidavit is a scratch and sniff. It's like everything to do with Aiden, and there's like one very little paragraph that has anything to do with Karen. And we can all be outraged together. Let's go back and hear what Cosgrove has to continue saying, because I just had to prove to myself that that warrant that we looked at that was attached was actually a warrant to seize only. And you would think that the case would have concluded when they refused to return a true bill, but apparently you can keep going back to a grand jury as much as you want in Massachusetts.
I've looked at the cases that Mr. Buzang has cited.
And Diaz relates to a warrantless seizure of the cell phones and a delay in seeking a warrant to search?
Yes.
Okay. And here we have a warrant that authorized the initial search of the cell phones.
No, a seizure.
Let me ask Mr. Buzang.
No, it only authorized the seizure. Am I insane? Anyone? It only authorized the seizure. He's wrong. I just pulled up the search warrant. The seizure warrant. It's a seizure warrant, okay? So I want to hear that again.
Relates to a warrantless seizure of the cell phones and a delay in seeking a warrant to search?
Yes.
Okay. And here we have a warrant that authorized the initial search of the cell phones.
No.
Let me ask Mr. Buzang.
Is there another warrant?
Why that isn't dispositive. Is there a case that talks about a
Buzang was clueless and let it go. Buzang doesn't know that this 31-page warrant that I just showed you was to seize the phones only, not to search it unless it allowed for seizure and downloading. Says Suze, hold on. Let me go back up here. Paragraph 3. But Suzanne, I'm going to show you. I see what you just emailed me, but I'm going to show you the one that was attached as an exhibit to Cosgrove's motion. Okay. So I see what you sent me, and it looks similar to what I have attached to the motion, but it says this. Paragraph 3 says, I am seeking the issuance of a warrant to search the following property. Any mobile devices capable of communicating and cell phones used by Karen Reed. And then it says, with 2 asterisks, seizure only, no search of data as outlined in affidavit. The data on any cell phone seized may be copied. So it says the data may be copied, provided no search of that data will be done absent further warrant or order of the court. Well, this is hella confusing. That's exactly what you sent me. And this is the part here. May be copied, but there's like it just says, it doesn't even say may be copied. It says A be copied, AY be copied. Provided no search. So they're allowed to copy it, but not search it. They can download and image the phone. They just can't search it. So are they saying that they already did download it, but they just never searched it? And really, if they wanted to indict her the first time, why didn't they? I mean, you're right. We're being gaslit. That's what I'm going with here, because I just really have no other way to explain it to you. Let's listen to this a little bit more. Thank you, Lamassus, for pointing it out to me, but it doesn't even say may. It says A.
Circumstance where there is a warrant that is issued to authorize the seizure of the cell phones, which is then where the ultimate search, the contents of the cell phones is delayed and therefore somehow prejudicial to the defendant and is suppressed.
Thanks, Tara.
I think, Judge, in this case here, the phones were seized
And voice
January
of your heart says
22nd.
if they downloaded it, why do they need the phone passwords? None of this is okay. Right. And if they had the ability or the permission to download it all the way back in 2024 and they didn't do it, like, is it like too late? Right. And Glamis points this out too, that AY is a true scrivener's error, because what if it says may not? What if it is supposed to say may not be copied? But, it's a scrivener's error.
2024.
Right, pursuant to my warrant.
To your warrant, exactly, Judge. And nothing's been done. The only reason something...
I understand, but do you have a case that says that when that's the circumstance and a year plus passes, they can't come back to the court to seek authorization to go into the phones when the court has originally authorized the seizure of the phones in the first place?
Well, yes, A. Lott points out that Commonwealth v. Arthur, which is a 2018 case from Massachusetts, involves an initial warrant to seize and an unreasonable 85-day delay in seeking a warrant to search. So, hello, Mr. Buzang, if you're watching, maybe check out Commonwealth v. Arthur.
Well, I think Diaz, Judge.
Well, Diaz didn't involve a warrant, apparently, for the seizure of the phone. It was a warrantless seizure of the phone. No judge had viewed the contents of that phone as potentially, or had ruled that the contents of that phone were potentially evidence in a case, right? That there was probable cause or a basis to issue the warrant. So the question is whether you have a case that results that arises in the context of a warrant authorizing the initial seizure of the phones, and then there's a delay in looking at the content of the phones or any other piece of evidence. Warrant authorizes the seizure of hiking boots, and there's a 1.5 year delay on doing DNA testing to see if the boots trudge through mud or blood or whatever the relevant substance is.
Sure, Judge. Well, I feel that the reasonableness in delays in obtaining a search warrant under the Fourth Amendment in Article 14 of the...
But we just looked at the warrant. It said that they may copy it, but they may not search it. Tara says, if it wasn't downloaded at all, then Buzang is correct. I believe the search warrant was to go back to search with another warrant. Amber said, thanks for your 5. I swear Turtle Boy's listening to you. His smiles are too connected to what you're saying. So funny. I could be wrong, though. Love you both. Oh, we love you more. I can't speak for him, but I love you more. Kyle says, I was here then. Oh, Maya Kowalski, I made my wife watch the documentary after the trial. She bawled for hours. I know, that was very sad. Thanks, Kyle. Tiffany says, you're a breath of fresh air. I work in oncology and come to your shows for a much needed break. Thank you, but today may not have been the break that you're looking for. Temeke from New Zealand says, hello from New Zealand. Love your channel. Hello, Turtle Boy, the man who started the Free Karen Read movement. You're a hero, bro. You got this, mate. Thank you for tuning in from down under. Mike B from the 413 says, back in 2022, Krupp gave an order on the Bryans phones. Was it the order, the preservation order for them to not destroy their phones? And then before they were served with it, they both destroyed their phones. That's interesting. Josh says, if they never downloaded the phones, how did they convene a grand jury against Aiden and Karen? They didn't use any phone data. Don't you think they should have? They didn't use any. Thanks, Josh. My head just popped off at Kazi. Thank you. Thank you, Mr. D-Head. Strange Credulity says, help me, Melanie. Is the Karen Read case not over? Well, no. Listen, we're not out of the woods yet. I mean, the case for the original charges of, murder 2, vehicular manslaughter with OUI and OUI. There was never a standalone OUI charge, but they did convict her of that only. It was leaving the scene. It was murder 2, manslaughter while under the influence of alcohol, and leaving the scene of an accident involving personal injury or death. Those are the 3 charges she was charged with. That case is over. This would be for witness intimidation. And there is no case that it's filed under because it doesn't exist. But they filed it under Aiden's case. I can't tell you why. We are back in the Upside Down. Where's Eddie with his guitar when you need him? Thank you, Strange Credulity, for tuning in from across the pond. Andrea Clark says, do they always have to cite a case? Yeah, I mean, you should have some case law to back up your position, and you should be fully familiar with it at the oral argument, because this judge likes to ask questions. And even at the end, he still took it under advisement, because I don't think he wanted an uproar in the courtroom when he said, okay, I'm going to allow it. Yeah, it was Sisitsky. Thanks, Dan. Yeah, I think he must be a little bit behind the day they walked in. So in your papers, you definitely have to cite case law, but there's always a case. There's always a case for your position. Like Lindsay Tyler says, plenty of case law to support her argument. Oh, we covered this before. Thank you for your 10. Nona of 3, gifted 5. Thank you. Norman says, if they want to find a conspiracy, they could look at the 11 people that were at 34 Fairview. Now, that was a conspiracy to cover up a crime. Tell them he never came in the house. Right. We'll get more information tomorrow. The phone call from Jennifer McCabe to her sister, Nicole, at 5:00-something a.m., right after she hung up with Karen Reed the first time. Thank you, Norman. Ms. Bouquet, this is about silencing Aiden, not about Karen, she says. Thank you. Tons of fun, 911. It's so scary that they are willing to do this, even when they know the world is watching. I had to take a break. I couldn't watch Krupp anymore. Thank you. If you got to take a break, you got to take a break. Edward says, because Krupp is conflating the seizure and search as one warrant. He thinks Diaz is not on point, as there is a warrant, ignoring, is it the right type? Thank you, Edward, for 5. All right. MJ sends an email and says, on 3/20/25, Hank Brennan tried a sneaky move in Turtle Boy pretrial hearing to get access to both of their phones on a consciousness of guilt premise. Right. That is the hearing where Karen Reed and the Dream Team arrived at the hearing. Yeah. And that was Judge Sisitsky. When Brennan is speaking to the judge, the phones already being extracted is clearly stated, if I'm not mistaken. He says Cosgrove has access to it, but he does not, etc. Does anybody remember that? You're going to make me pull up the hearing? Because I will. You think I won't? I will. I will. 3/20/20. That was March 20th. You know what comes up on the Google search? My stream from that day. We'll roll the tape. If you think we won't, we will. Let's see. Who's got the this is March. Yeah, this is Sisitsky. Okay. All right. I got it. But unfortunately, it's Core TV's feed. So let's check it out here. Unless I can get a better one.
Let me start by saying this. There seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will hear that as well. So with regard to my order, let me start by saying this.
Trial channel, thank you.
Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that, quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Carney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Carney and counsels for this defendant, Reed. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the three categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Carney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Carney and Ms. Reed during the time frame in question with regard to these three articulated categories be produced. However, subsequently, the special prosecutor in Mr. Carney's case, in possession of the documents in question on March 26, informed the court that, one, there are, in fact, a substantial number of communications within the documents and data requested that are indeed communications between Mr. Carney and Ms. Reed's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So my order did not specifically exclude from production communications between Mr. Carney and Ms. Reed's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Carney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production and we can move on. If that's not the case, I'd like to hear why.
Sure. May I?
Yes, you may.
Oh, he gives me heebie-jeebies. And this is before they march in, so
I think
get
there are
ready.
two separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Bradel, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney. When Your Honor asked the question, I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened.
Talking
but
about
that
Aiden's
wasn't my
phone.
answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other.
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective of the attorney-client privilege between Mr. Kearney and his attorneys, Mr. Bradel and Mr. Betterow.
Okay, well, we all agreed, counsel, that those in fact would be privileged communications without question.
Of course.
So let's turn to, if you would, the second issue, which is one that you raised.
Okay. Karen and her team were in the basement of the courthouse watching YouTube when they saw that this hearing was going on, and now they're going to march into the courtroom. I'm so glad we're watching this again.
In your affidavit, you specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Reed's lawyers are attorneys for Mr. Kearney. I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case, docket 0313, that there was a position taken by Attorney Bradel. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy to Mr. Kearney. And then Mr. Brady responded, well, it's a little more complicated because we know he was under investigation along with Ms. Reed without any resultant charges. So we would contend that does not fall under the umbrella.
Right.
After more questions by the court, Mr. Brady answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Betterow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship between the two. Inevitably, and after that, Attorney Betterow attempted to file an appearance on behalf of Ms. Reed. And in that, there was a supplemental motion, and it's docket 549 and on 0117.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Exactly. And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand exists. And so I do not know what is in these phones. I have not asked. I don't want to know unless it's pursuant to a court order. But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the last date. But those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043. In that pleading, it is set out by the Commonwealth pleading that there is, in fact, information demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It's suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8823 when they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there because I think we've reached a point where I have a threshold issue that may require either a
I don't remember it taking this long before they walked in
Bishop
either.
Franklin
I thought they walked in way before this.
Call or some inquiry
different hearing?
into the nature of the privilege that may or may not be asserted by
It's not the right
Attorney
hearing.
Bradel. And so I think it's appropriate at this time, Attorney
It's
Bradel.
not the right hearing. Okay, wait, hold on. But that was a good one. I'll still allow it. I think this was from March 30th, and the one that we're looking for is from March 20th. So, no, they're coming in very soon. But I don't see Aiden and Bradel at the table, and I think they were at the table. This is the one after. No, it's not live right now. No, it is not live right now. Aiden and Bradel were sitting at the table when they came marching in. And so if somebody can send me a link to that video, that'd be great. Because trying to find this on the Trial Channel's playlist that when I don't know when I think it was March 20th. They were at the table. Same judge, though. If anybody wants to send it to me, just send it to me right now, because otherwise it's going to take me a while to find it, and we'd have to do things on the fly here. This is the right one. We'll keep playing this one, but
that I turn to you.
I thought Turtle Boy
not
and
with
Bradel were
regard
at
to
the table.
protective order, but with regard to the issue of whether your client claims a joint defense
We're gonna keep playing it
agreement and related privilege to communications between himself and
Cosgrove is sitting there?
attorneys for Ms. Reed, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said
Bradel is on
in a
Zoom for
much
this.
different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So we are not asserting that. There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this, Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed. So why would communications to other parties besides Ms. Reed have any relevance? And in fact, in your order, you just say that the only communications that are on the table
Found the other one,
here,
so I
so to
got it.
speak, are communications between Mr. Carney and Ms. Reed.
I'll stop you right
Nothing
there,
about
Attorney Bradel, because you
lawyers or
raised an excellent point, and that point being is that point from.
All right. The
because
Commonwealth says there's no attorney-client privilege. Bradel, who represents Kearney, says.
Stop. All right, I have Young Jerk's feed from 3/20/25, and Mike is cool. He lets me play it, so we're going to look at that. That was the 30th, because he's referring to his order from the 20th. So, all right, hopefully this will be.
I want you to know what's up. I'm arrested for husband-wife communications, arrested for that journalist source materials, of which there's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampron, it talks all about undue delay. They had this back in February of 24, and here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say, we will find something criminal in those phones. Thank you, Your Honor.
Oh, this is already when they were already sitting down.
So,
this doesn't get their walk in. Oh, for Christ's sakes. Does anybody have the link to it? That was Young Jerk's feed. So I'll take that down. That's just like a 6-minute clip. Video. Bradel's on the phone. Yeah, this is it, but they've already walked in. I wanted to get the whole walk in. Oh, I found it, I think. No. Three 2025. The Boston 25 has it up, but this is Judge Cannoni. And so that happened, right, because after this hearing with Sisitsky, then they went to, thank you. Then they went to Cannoni's courtroom. Okay, thank you. Thank you, MJ. Got it. So collaborative. All right. And that's why they were confused, because they were in the basement waiting to go see Judge Cannoni. And then what had happened was they were in there doing this without them. All right, let's go. We got it this time.
You're very well aware of that person's name. It may be, but I don't know that. And that's why I've refrained.
Let me ask you
from
this, counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove, and that they have the reports that have been generated.
As the underlying.
There you go. Brennan just said they were given to Cosgrove. Thank you. It took us a while to find it, but there you go. That's what Brennan said in front of Sisitsky. This is June 20th, 2025. Shout out to MJ. Let's hear that again.
Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove, and that they have the reports that have been generated.
Has the underlying data from the two phones in question been assembled?
I understand that it has.
Two phones. Are they talking about Aiden's phones, or are they talking about Aiden and Karen's phones? And I thought that's the reason why Aiden and Bradel were so confused, because they're like, this doesn't even involve our phones. They were talking about Karen's phones. But even if we go all the way back to Law and Crimes feed, it starts like in the middle of it. So I'm going to go back to the very beginning of Law and Crimes feed. This is where it starts. This is Aiden's phones, not Karen's. Both phones are Karen's. Everyone's giving me mixed information.
Are very well
Karen
aware
has two phones that were seized in January 2024. Hang on.
of that person's name. It may be, but I don't know that, and that's why I've refrained.
Let me ask
from
you
it.
this, counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove, and that they have the reports that have been generated.
Has the underlying data from the two phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as.
Yeah, Jason might be right. I think they filed it under Karen's case number, but it was about Turtle Boy's phones, and that's why they were confused. And then they come up and they say, but this is her case number. She's got standing. Because I think the judge is going to say, well, you don't have standing because these aren't your phones. Let's just keep watching.
It relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Carney's phone, is that there was a relationship between Karen Reed and Mr. Carney, in which Ms. Reed would provide information indirectly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Carney targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Carney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023, 7 months of material that ostensibly could include everything from meeting notes, calendar.
Come back to your screen, because here they come. This is when they come in the door. I may have to rewind it and do it on slow motion, but I'm going to do it at regular speed right now. This is 3/20/25, Suze. March 20th, 2025. Before trial number 2, obviously, because Brennan's involved. Okay, here we go.
Calendar invites,
Here they come.
text, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
Yanetti's face is everything right now. Karen Reed, she's going to give him the death glare watch.
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team unless they have standing in this.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're...
Can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of the We didn't see which case number was called for this Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Cannoni, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights and the issue.
This meeting is being recorded. Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
It's her case.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
Then she needed to be here and she has a right to counsel, and we have a right, we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but
which can be dealt with at a later time. Those are what you're...
You wrong, Judge. This is filed under Karen Reed's case number. She's the defendant facing murder charges. You wrong. She absolutely has standing. It's her case. But again, you're right. They were looking for information from Turtle Boy's phone to prove Karen Reed's consciousness of guilt. We're still watching this anyway, because this is one of my favorite days.
Suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
This is, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or the disability standpoint, that can be dealt with at a later time. But the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth has, there's been Rule 17s for 2 years on this case.
Yes, yes. This is like the bait and switch, right? They file it under Karen's case number, but it's regarding Aiden's phones instead of filing it under Aiden's case numbers because he had open cases at the time. Just like they did today, they filed it under Aiden's case number, but it's regarding Karen's phone. Does anybody see a problem with that? Or is this a shell game? It's opposite day. Today's opposite day.
Over and over and over, Your Honor, the Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Kearney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. Correct. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're prepared.
And did you give the court notice of that?
We did to Justice Cannoni.
Okay.
Day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Mrs. Little is prepared to address the court on the very issues Mr. Brennan is bringing up.
I'll take it under consideration. is there any issue, counsel, with the current configuration, the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And
Can't
once
be a little
Mr. Brennan
mouse.
is finished,
Right.
before the court makes the ultimate ruling, and once Mr. Gradle is finished, I think we have we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection.
Right. Why didn't Brennan do anything with Karen's phones if they had them? Great point. Task and conquer. Great point.
Procedurally, if counsel wants to join in my file, that's an issue in terms of the filing. So, just put it
Thank
down.
you. Thank you,
Well,
Attorney
Your
Brennan.
Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow.
Yeah, I swiped out. I swiped out again. I haven't done that in a long time. I have a laptop in front of me, so sometimes when I swipe to try and get something on my screen, it swipes me out of the stream. We're back, though. I stopped right at the exact place where we left off. I got a song in my head. Hey, thanks for the lovely bouquet. But that's my problem, not yours. Okay. There's a little sign in the corner. It's like a large helping of, I baked you some shut the fuck up cakes with little Debbie on it. So, you know, we have that.
A party in this case, and I'll allow her to sit at council table and to have representation.
He just flipped all of a sudden. You know why? Because the courtroom is packed full of people. The swipe has become nostalgic. Ms. Scarlett says it has.
And I'll consider whether I'll hear from her counsel concerning the substance of the motion and her
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating us.
So, ADA Brennan, with the court's apologies for the interruptions, the crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and I've identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at Section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe, to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant
information that we've provided. There is.
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel for Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed case, Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the 2 phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth v. Kearney case, docket number 53, Commonwealth's revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses.
Well, that's where they end their video here on Law and Crime Trials, but I'm going to take it back to the walk-in and just play it in slow motion because that is one of my most favorite days of YouTube ever. Let's take it back. Okay, here it is. And I'm going to even like mute him because otherwise we'll hear his voice going really slowly. We don't need to, nobody needs that. Needs that? Nobody. All right, let's do it at like 0.75 speed. Here it is for all of us to watch again and have a little bit of nostalgia. Oh, when the saints go marching in. Oh, when the saints come marching in. It has to be even slower, I think. Hold on. Continue to do it at half speed. Let's do a little bit. There we go. Or whatever song you would like, you can sing in your own head. Here they come. Fantastic. 1, there's a lessee coming through first. Here comes Mr. Jackson. He doesn't really look up Brennan, does he? He puts his briefcase down like he means it. Yannetti's got the knives, blades coming out of his eyes. Look at him. It's like the death stare. Ms. Little with her roller bag. Here comes Karen. And the court officer is going to come right over with a chair for her. He's pulling up chairs. He wants everybody there. Here she goes. She's giving him the death stare. If looks could kill, they probably will. Games without frontiers. I mean, that was fantastic. What a day that was. Oh, the old days, you guys, the old days. Hard to believe that was March, right? March of 2025. Well, thank you to Cynthia, who sent me a press conference from after court today. But the problem is that it's Grant Smith Ellis's footage, and he would copyright strike me. I probably think he would. If anybody else can find any other footage from after court today with what Bradel said, I'll take it. You can email it to me. I don't want to play it his because he would copyright strike me because that's the kind of guy he is. That's the guy who called for me to be disbarred. Remember? That's the guy who like accused me of going to Cancun with Alan Jackson. Tara says, if it wasn't downloaded at all, then Buzang is correct. Yeah, we looked at this before. Thank you for your several super chats in a row. Tara. Fairy Raven pointing out all the way from Ireland. Remember, Aiden has always said there's nothing to find on either of their devices pertaining to witness intimidation. I believe him. Thank you. Tara said she had her whole case on her phone or her phones. Thank you. I can't read your name. JFooder1. Maybe Karen could higgy her phone and SIM card. No, they already have her phones. They've had her phones in possession since January of 2024. They never gave them back. Thank you for your super chat. Kyle says I worked as a PI for an insurance examiner. I couldn't even investigate agents and clients on companies that I did personal business with. This is insane. Yep. Jill says, why wasn't the attorney prepared? I miss AJ. Thank you. A lot says Diaz, no warrant to seize plus 1, 2, 3 delay. Arthur, like this case, warrant to seize plus unreasonable 85-day delay. Diaz, no warrant to seize plus 123-day delay. That's because he was arrested, right? And they didn't need one. Thank you, A lot, for doing the Lord's work and for your $10 super chat. Tara says, don't threaten us with a good time. Oh, you mean watching the video? Thank you. Ceasing to be my problem has been here for 7 months. It says her iPhone account will automatically sync all of her current data. This is why they're asking now, because they know nothing on phone up to January 24th. Well, I don't think they're going to be able to use anything after January 24th, if that's the case. But also, I don't know if she got a different phone number. If I were her, I would have gotten a different phone number, knowing that with an iPhone, everything syncs. But I have no idea if she did or not, but that's a great point. Lola the Good Dog says, why wouldn't the judge agree to hold off on the search until Cosgrove or DA conflict is resolved? That would have been the right thing to do. I agree with you, because I don't know who's going to respond to the mega motion. I think we're going to hear Mark Betterow curse. Thank you. Thanks, Lola the Good Dog. Tara, again, with another super chat. They had court with Bev that day. Yes, they did. You're right. And that is why her team was there. And they did this on the sly in front of a different judge instead of why this wasn't done in front of Cannoni, who heard all the Rule 17 motions for that case. I don't know. Kyle says, catching up. Brennan's conscience is seared with a hot iron. Repent, confess, and put on Christ before it's too late. Hanky. Thank you, Kyle. Felicia says they wanted Tex Yannetti sent Aiden and vice versa, right? Thank you, Felicia. Mason says, will Karen suing Tully have an impact on this? I don't think it's going to have an impact on whether or not they can search her phones. I don't think so. Shouldn't. She's suing Tully for a violation of her civil rights, which may also include the seizure of this phone. So it's a good question, but I don't think that this judge is going to entertain anything outside of whatever he feels like entertaining, because we heard him, right? Thank you, Mason, for your 10. Sandra says Karen's lawyers all need to be solid. This lawyer was not strong. That's the only way to beat the corruption. Thank you, Sandra, for tuning in from Canada and for your super chat. And, did he just think this was going to be easy? Like he was just going to file a motion to get her phones and her car back, and they were just going to be like, okay, here you go? I doubt it. I mean, he probably thought that, but we've seen this film before. Laura says, remember when the chivalrous court officer got a chair for Eliza? Yes, we just watched that. Reminds me of the silent support so many in law enforcement have for Free Karen Reed and Free Turtle Boy. True. Thanks, Laura. Will says, I love the shut the fuck up cakes. Thank you, Will, for tuning in and being here for 3 months. Ms. Mojo Horizon, history in the making, never forget, needs to be shown. Needs to be shown, and law see Karen and her team walking in this court with Turtle Boy. Yeah, that was amazing, right? Never forget. David Reese, phones are kept on airplane mode during an extraction. Thank you. They still have them, though. Are they still in airplane mode at this point? I don't know. But somebody said that mainstream media is picking it up, and that these are the headlines. If anybody wants to send me anything, I will take a look. Rich, I don't know. You sent me something, but it's all blacked out. I can't read it. Maybe you have like a different font on your computer. Thank you for your name and clarifications, but I can't read it because there's like a black box over your entire email. Maybe they already looked at her phones. Yeah, I mean, listen, we saw what they did with Brian Walsh, right? We saw what they did with Brian Walsh. So I don't know. We're not out of the woods yet, guys. We're just not out of the woods yet. Corrupted in Norfolk Tech. Corrupted Norfolk District Attorney's taint team. It says, I thought Mr. Betterow said they would have Doolin as the judge here on out. Did he say that for the mega motion? I don't know. We heard Doolin say at the last hearing, I might not be here next time. And I don't remember why that was. If he was getting rotated out, if he was on trial December 5th, I don't know. Well, Ted Daniel tweeted, but I don't see any video here, Tiff. But Ted Daniel tweeted, after the hearing, Aidan Carney's attorney, Tim Bradel, said, Carney supports Reed getting her phones back. And he said Special Prosecutor Cosgrove should not be involved in the ongoing investigation for the same reasons Cosgrove was removed from another one of Carney's cases. Yep. Thoughts, questions, comments, concerns? Well, Glamassoos, just because it says Frenier is the assigned judge for the 12-5 hearing as of now, Doolin is in civil court. Who knows? I think Krupp is going to want to keep this. I don't know. A lot of people are saying Krupp's going to want to keep this. Wild. So it looks like we're coming back on December 5th for all of it. The mega motion and the motion to recuse. And I think Buzang got a couple of extra days or a week or two to respond or to get with Cosgrove to agree on a taint team protocol, right? Cosgrove's getting his hands on everything and he shouldn't be. He shouldn't be. I have so many problems with this. I don't even know where to begin. So I need a little more time to digest. But like, where are the grave concerns? Right. Little Mama says, I have grave concerns. Judge Canody granted release of the car and the phones. Right. I think so. I don't think I ever saw an order on that. Was it just scribbled somewhere? I mean, so technically, could they have filed that under the case number? Could Cosgrove have filed that under Karen Reed's case number since technically she's still on like probation for a year? Probably. Like, why was it filed under Carney's? It just makes no sense to me. If anybody can make sense of that for me from Massachusetts, please let me know. Kyle says, Krupp the cop that delayed. Krupp the corp that developed weapons for what it's worth. Okay, that's not, I can't even say that word on the air, so thank you. And Will Wallace gifted 20 memberships. Wow, Will, that's super generous of you. Thank you very much. And for the 20 of you that were gifted, thank Will Wallace. Thanks, Will. I think you started watching me, Will, after I was on with AV, right? Love AV. I love AV. Yeah, poor Bradel just got so disrespected this week by all three judges. I mean, I don't think the judge could be recused on a conflict of interest. I think Cosgrove should be conflicted, as should Marcy's office altogether. Well, I don't know what to make of this. So hopefully brother counsel will do the Lord's work and look up all this case law and tell us what he thinks. Hopefully we're on the same page about this because otherwise I'm being completely gaslit. Peaceful dreams, everyone. Try and stay above the fray and above the somebody Matt's Tea Party says Will Wallace is handsome looking. And Louise Young 51 says Krupp has already made up his mind. He will allow it, unfortunately. I don't know. Bradel, but it's not Bradel's motion to argue. That was not Bradel's motion to argue. That was Reed's attorney's motion to argue about the searching of the phones. Yeah, they're all pissed because Bradel filed the emergency SJC appeal, but that's on Kelsey Fitzsimmons. You think? I mean, that carries over to Aiden's cases. Noodles Mama says, Melanie, do you think these judges just don't like Turtle Boy for putting corruption out there, and they don't like Bradel for being his attorney. I mean, that would be so improper. But at this point, anything. At this point, nothing would surprise me, I don't think, or shock me. Patriotic says everything is connected. I think Bradel's doing a great job. I mean, I know that he was on no, Betero was on the Zoom, but we didn't hear Betero speak at all. Like, he didn't even enter his appearance, but I saw him on the Zoom. Give us back Doolin. I don't know. I like Doolin too. No, I haven't looked at your merch idea since the last time you sent me a super chat because I'm not checking my email while I'm on the show. But if you insist, I'll take a look. Can you tell me again what your name is? I've literally, my inbox is overflowing. There's like 700 emails from today alone. So I don't know where to find it. Tell me where to find it again. I'm sorry, but it's like impossible for me to, Jasmine, it's impossible for me to like stop what I'm doing, look something up. Oh, that's cute. It makes me into like a superhero. I mean, damn girl. Damn girl, if I could have this this character's body, I would take it in a second. Hold on. Here's what it says. Attorney Mel Law, Law, and I mean, that is a very, very kind and generous representation of me. If I was like a superhero and had a six-pack of abs, dark hair, and was about 30 years younger. Thank you. That is very sweet. I appreciate it. Technical out says, I'm getting pretty ticked about all these judges being unprepared every single time. Piney Woods, did you practice in Massachusetts? Do you practice in Massachusetts? Because I need like a Massachusetts lawyer that's not connected to this case because, you know, Betero can't really talk about it. To tell me that I'm, you know, not completely insane, because I really may be. Right. And somebody says here, and this is a good comment. Lady Dutch, in my opinion, these courts are just causing undue stress and over-the-top drama in the YouTube world on these two cases. It is really sad that some people just like the drama. I'm so glad that Melanie is mature. Thank you. I mean, I don't understand really what's going on out there because I did unplug for a couple of days. And so I really, you know, somebody sent me something like, they sent me an email that said something like, you know, you're being trashed on Reddit, and like sent me the Reddit thread. And I'm like, that's like the girl in high school that pretends to be your friend. And then she's like, you know, what so-and-so said about you. And then goes on to tell you like all the mean things that people say about you. Like, do not send me like things that people are trash. I don't want to know about it. I don't want to know about it. Why would anybody send me that? Don't do that. That's not a nice thing to do. Your emails are automatically going into the trash and I'm not even going to open them. But it's like, do you think like you're helping me by sending that to me? Because I don't care. I don't care. Who does that? Like, why would you do that? Oh, look, you're on this Reddit thread and they hate you. Okay, great. And you're a viewer and you're sending that to me to be what? Helpful? I don't care. But it pisses me off when people do that. So I'm just saying that. Don't do that. Please don't do that. JP Guthrie says, it's just me. Karen's attorney didn't seem as prepared as he should have been. I agree. I agree. He should have had his argument sewn up tight and been a little more forceful about it. But I think he just like thought it was going to be easy, but you should never think it's easy, especially not in Norfolk County, especially not in Massachusetts, especially not anything having to do with Karen Read, because they will stop at nothing. They want to pin something on her because this goes way deeper than just apparently the murder of John O'Keefe, because something else happened to John O'Keefe and they're not spending any time trying to figure that out, are they? Why not? I mean, wasn't this whole thing and also this whole community that we built? I don't like the word movement because I don't really think it was a movement necessarily. I think it's a community of people who believe in justice and things being done properly and procedure and constitutional rights and justice for John O'Keefe. And there was a wrongful persecution of a woman who did not hit John O'Keefe with her car because he was not hit by a car. But why is it that they're spending more time trying to convict Karen Reed of something than trying to solve the fucking murder of John O'Keefe? Why? Sometimes you got to use that word. Sometimes it's the perfect word. It can be used as an adjective, a verb, a noun. It can be used as anything. But where's the investigation into that murder? Because if he wasn't hit by a car, something else happened to him. And I don't know, there was 11 people in that house. Maybe start there. Maybe you got it. Maybe 10 people. Maybe you got a 10% chance of getting it right this time. It's insane. Why is that not being looked at? Why is that not on the front burner of the Norfolk County District Attorney's office? Or like, I don't get it. I don't get it. When Melanie swears, I feel like I'm in trouble. I mean, no, he wasn't prepared because guess what? They're going to stop at nothing. They're going to stop at nothing. Krupp is going to let him have the phones. I don't know if there's anything in the phones or not. That was Karen's. No, that's the attorney that's only been handling the release of property. Right. Old Line Red says John O'Keefe wasn't hit by a Karen Reed. Aiden Carney didn't intimidate any witnesses. Eyes on the prize, people. Thank you, Sherry, for gifting a membership. Leave the drama at the door says, so now we have lawyers with no status. I don't know what you mean. Thanks, Sherry. Gifted another 5 memberships. You're awesome. And Tell the Truth became a member. Welcome. And Technical Percy says, I'm getting pretty sick about these judges being unprepared every single time. Here's the other problem I have, okay? Every hearing, there's a different judge assigned, okay? I'm used to, New York, where things are done, I don't know, I would say the right way. Maybe it's just because that's the way that I'm used to after practicing law for over 30 years. But when your case gets assigned to a judge, your case is with the judge for the entire time. Unless the judge retires, okay? You don't bounce around from judge to judge to judge, depending on the week or the month. The judge knows your case. He's been there for every motion. He or she has decided every motion. They don't jump around like this. And that's why it's insane. And we see this in every Massachusetts case. One week it was Judge Cannoni. The next week it's Doolin. The next week it's Halal. The next week it's name a judge, Katie Rayburn. I mean, everybody has had their hands on every case. It's insane. So, all I can say is this makes me happy. So I'm sharing it with you again from yesterday. This is Good Citizen's grandbaby. She's 5 months old and she's wearing a little outfit that grandma made for her. And my goodness, look at those eyelashes. And she made her a little Melanie Little merch onesie that says, be cool, be kind, stay classy. Cupcakes are sweet and sassy. Just have a good attorney. And there's a cupcake on her outfit. And God bless you, Good Citizen. That makes me so happy every single time I look at it. And I don't know the baby's name. Otherwise, I would say, but she said I can show it. So I'm not doxing the baby. Love it so much. Cuteness overload. And Leave the Drama at the Door has grave concerns. We all have grave concerns, but nobody cares. Nobody cares. And on that note, we're going to break for the day. I don't know what we're going to do later, but maybe something. You want to do a cupcake invasion on someone? Let's see who's live right now. It has to be a friendly, though. We're only going to a friendly today, you guys. I have no tolerance for the unfriendly. And remember where the friendly came from. That was Alan Jackson, right? Looking for a friendly. That's why they didn't search the house, because they were waiting for a friendly, or they didn't let him in the house until they got a friendly. Just waiting for a friendly. It is 5:01 p.m. Or here's your choices. Hold on. Wait, let me just see something. I don't know if it's live though right now. Is it live? I guess it is. All right, look. All right, cupcakes. We're going to do the Lord's work right now, okay? Because you guys are the greatest. Billy Bush only has 30 people watching his show right now. Billy Bush only has 30 people watching his show right now, and he's a hell of a lot more famous than I am, okay? So we're going to do a cupcake invasion to Billy Bush. All you got to do is buckle your seatbelts. Tell him I sent you. Tell him that maybe one day he'll get a hole-in-one like Melanie Little. Okay? He needs more than 30 people watching him just because I like him and he's a nice guy and he's on a psilocybin journey. So really, he be tripping. Okay. So get on over to Billy Bush, buckle your seatbelts. I love you all. And thank you all so much. Thank you all so much for being with me today, for spending your entire day with me. Thank you to the moderators for making this a fun, classy place to hang out. Thank you, Jasmine, for sending me that awesome superhero. You're the greatest, all of you. I will see you tomorrow, except I just don't know exactly what time it will be tomorrow. So make sure you have your notifications set. Make sure you're still subscribed and get out there and do the Lord's work and tell Billy Bush I sent you. All right. His brother is supposed to announce today he's running for the governor of Maine. Okay. Do we like him? I don't know. I don't know anything about it. All right. I've been on with Billy several times. Several times I've been on his show, but I'd like to have him come on this show to tell us about his psilocybin journey because, we be tripping. All right. Peace out. I love you guys with all my heart. Buckle your seatbelts and get on over there to Billy Bush. All right. Peace. See you tomorrow.